Are NFTs a scam, or are they the next big thing? Legally speaking, it's a question between Uber and Theranos. Uber was able to sidestep regulation to become a billion-dollar company and basically is interwoven into the fabric of society, whereas Theranos tried to fake it until they made it, but they ran up against physics and biology and were just a giant fraud. NFTs are probably somewhere in the middle. They're certainly not unicorns that are going to solve all problems, but they're probably not all completely useless. And either way, they raise fundamental issues of law. So today we're going to cover only the legal problems associated with NFTs. Others have explained the non-legal issues. For example, Dan Olson at Folding Ideas did a fantastic video called The Line Goes Up. Which is not to say that the technology can't overcome these problems, but right now there are some fundamental issues of law with the way that NFTs are used now. And I see three main categories of issues with NFTs: on-chain problems, off-chain problems, and what I call innovations so mundane no one should care. Now, to get to those issues with NFTs, we first have to define what an NFT is, because I think almost everyone gets it wrong. An NFT is a non-fungible token. It is an entry on a decentralized ledger called a blockchain. A blockchain is a permanent, unchangeable digital ledger that's used to record transactions in blocks of computer code that are time-stamped and linked together. The code will reveal the history of a digital asset, where it originated, who purchased it, and any subsequent transfers. And in the digital world, the token can be assigned specific uses and properties. Now, it's non-fungible because it is said to be unique, unlike something like Bitcoin, where every single Bitcoin is interchangeable with another one. It's like a dollar bill. Every dollar bill that you possess effectively does the exact same thing as another dollar bill. Same with a Bitcoin. However, an NFT is said to be unique, so they are not fungible with each other. But at this point, let me turn it over to someone more technically minded, my friend Steve Mould, to explain how an NFT actually operates, because it's illuminating. So Steve, how does an NFT work?
NFTs work in a very similar way to Bitcoins. We track who owns what Bitcoin on a distributed ledger, as you mentioned. In the case of Bitcoin, that distributed ledger is called the Bitcoin blockchain. But NFTs exist on a different blockchain, typically the Ethereum blockchain. The difference between Bitcoin and Ethereum is that the Ethereum blockchain is programmable. You can write programs and publish them to the Ethereum blockchain. These aren't programs that you would run on your computer. These programs run on the blockchain and they interact with transactions on the blockchain. For example, you could write a program and publish it to the Ethereum blockchain that launches a new cryptocurrency to rival Bitcoin. But it's not just limited to cryptocurrency. You could use the Ethereum programming language to do all sorts of things, including, for example, making NFTs. These programs are called smart contracts, which is misleading because, look, here's an example of a smart contract. There's no legal language in there. It doesn't function as a legal document. Though I can see why they wanted to call them smart contracts, because they enforce transactional rules on the blockchain. Just like normal software, once you publish a smart contract to the blockchain, you can interact with it by sending it commands. For example, you could send a command telling it to mint a new NFT, or you could send a command to change the owner of an NFT. Smart contracts can be used for much more than just cryptocurrency and NFTs. For example, you could write a smart contract that acts as an escrow between people buying and selling NFTs. The definition of an NFT is quite strict. By consensus, we've agreed that if a smart contract behaves in certain specific ways, as defined by a standard called ERC 721 and one other, then we call that an NFT smart contract. So how does all this relate to digital art? Well, let's have a look at the most expensive Bored Ape ever sold. That's Bored Ape number 2087. Let's head over to Etherscan, a website for exploring the Ethereum blockchain. This is the address of the smart contract that mints Bored Ape NFTs. ERC 721 contracts can be queried in certain ways. For example, I can use the owner of query to find out who owns a particular NFT. So Bored Ape 2087 is owned by this person. The ERC 721 standard also includes something called the token URI. If I put 2087 in here, I get this. This is a URI on the public internet for anyone to see. It's an IPFS address, so let's head over to the Brave browser and see where that takes us. This is some machine-readable JSON code, but let's make it a bit easier to read for humans. And look, you can see that's the URI for the ape image itself. And here are some attributes of the ape. For example, its mouth is bored cigarette. The background is purple, the fur is trippy, the eyes are angry. Let's grab this image URI and stick it back into the Brave browser, and there it is. So when you buy an NFT that's linked to a digital artwork, you're buying a unique location on the Ethereum blockchain that points to a text file on the internet for everyone to see. Inside that text file is another URI that points to the image itself, again, on the internet for everyone to see. Believe me, there are a bunch of weird technical details that need to be talked about associated with NFTs. I cover all of that over on my channel, but the bottom line is when you buy crypto art, you're buying a line in a tamper-proof ledger that points to a publicly hosted image file.
So at the end of the day, to summarize, I think the best analogy for an NFT is not digital property, as a lot of people like to claim. I think the best analogy for what an NFT actually is a receipt. It is a receipt of some transaction. A buyer and seller interacted in some way, and an NFT is a receipt of that transaction. That receipt often links to something off-chain. Often that is a JPEG. But the receipt itself doesn't really tell you what the transaction was. To know what happened in that transaction, you have to look at the terms of the original sale, the contract. You also have to look at the reference work. Often that's a JPEG. But the NFT itself is simply an entry in a digital ledger that's kind of like a receipt in the real world. Okay, so with that understanding, I think we can get to the first category of legal problems associated with NFTs, which are the problems that are inherent on chain. And for that, I'm afraid we're going to have to talk about fundamental contract theory. Honestly, I didn't think that this video was going to require me to get back to first principles of contract law, the kind of thing that you learn in your first year of law school, and yet here we are. And we need to understand how a contract works, how it binds the parties, and what the limitations of contracts are. And I know that sounds super boring, but I'm going to explain that with wrestler and Renaissance man John Cena. Because in 2017, John Cena contracted with the Ford Motor Company to buy the new Ford GT, the new hottest sports car at the time. In order for him to buy that car, he formed a contract with Ford. He offered to pay them hundreds of thousands of dollars, and Ford offered to give him a Ford GT. But in particular, there was one term that Ford included in the sales contract. John Cena had to agree not to sell his Ford GT for 2 years. And that is a perfectly enforceable sale contract. Ford doesn't have to sell that to anyone. And so to make sure that John Cena didn't turn around, flip the car for hundreds of thousands of dollars, they made him promise not to sell the car for 2 years. What did John Cena do? He turned around and flipped the car almost immediately and made hundreds of thousands of dollars. So what could Ford Motor Company do? Ford could sue John Cena for hundreds of thousands of dollars, and in fact, they did sue him and they settled for an undisclosed amount. But the really interesting question is, what can Ford do against the person that bought the car from John Cena? And the answer is absolutely nothing. Because there's no contract between Ford and the person that bought the car from John Cena. The secondary buyer is said to not be in privity with Ford. John Cena and Ford are in privity. They have an actual contract, but there's nothing linking Ford and the downstream purchaser. So what in the world does this have to do with NFTs? Well, here's the thing. We talked about how an NFT doesn't really have any attributes in and of itself. When you're buying an NFT, the real thing that you're buying is bound by the contract between the buyer and the seller. Those are the primary purchaser and seller. There are some times when there is no contract, we'll talk about that, but theoretically at least, the value of the NFT is decided by the contract terms between the buyer and the seller of the NFT. But one of the huge fundamental problems that we'll talk about a lot in a second is that in practice, there's rarely any contract between the initial primary buyer and the secondary buyers, and then all of the downstream buyers later on. And on top of that, there is zero contractual privity between secondary buyers and the original issuer of the NFT. That's a real problem when the only value associated with an NFT comes from the initial sale terms. So let's talk about an example of this in practice. Many people are familiar with NBA Top Shots, which was designed by Dapper Labs. NBA Top Shots is an NBA platform that purports to allow you to own moments that happen in the NBA, often small snippets of videos related to NBA plays. Now, when you buy an NBA Top Shot NFT, the transactions are registered on the Flow blockchain, which was basically created out of whole cloth by Dapper Labs to facilitate the transactions of NBA Top Shots. When you initially buy an NBA Top Shot, you get limited rights to use and view the NBA Top Shot only within the NBA Top Shots platform. But here's the thing, NBA Top Shots is a private marketplace. The NFTs only have any real value when you use the walled garden of NBA Top Shots. You have to use their app or their website for the NFT to have any functionality at all. But in a way, it works because everyone is on the same platform. Effectively, NBA Top Shots is simply a normal Web 2.0 website where you're allowed to buy and sell things only within their specific platform. And the terms of sale travel with the particular NFTs because everyone is buying into the same system. If you somehow got an NBA Top Shot NFT and was able to sell it on a different blockchain, well, odds are the terms and conditions don't flow and you have an NFT that has zero value at all because it won't even work with the original NBA Top Shots platform. So if you're not NBA Top Shots and you're not forcing everyone to use the same walled garden, how do you bind secondary purchasers? How do you even know what you're buying when you're buying an NFT? Well, that is incredibly controversial. Now, another famous example is the Bored Ape Yacht Club that is famous for selling NFTs of monkey cartoons. Now, you can buy a Bored Ape NFT on OpenSea, which is a large marketplace for NFTs. When you do, the Bored Ape Yacht Club says that you get access to certain perks. These include getting access to their Discord server of like-minded purchasers of Bored Apes. But for the most part, those are perks that are offered off-chain and by the originator of the NFTs. Bored Ape could change their mind because it's questionable whether the terms and conditions travel with the downstream purchasers of every single Bored Ape. If those terms and conditions legally fail, say Bored Ape says they're not in privity with all of those downstream purchasers, and then they decide to cut off access to maybe some bad actors who are spamming the Bored Ape Discord, well, then those purchasers who spent hundreds of thousands of dollars may have zero recourse. Because if they're not in contractual privity, there's nothing that binds Bored Ape to provide those things long term. They may in fact provide those things, but they might not legally be required to. Now, if you're a normal website, you'd probably provide what's called a click wrap agreement. That's one of those contracts that you kind of scroll through and then click I agree. Well, that provides a whole bunch of terms and conditions. Sometimes those bind the users, sometimes that binds the platform itself. Now, when it comes to NFTs, you could provide a click wrap agreement. I don't see that being done very much, but there's a fundamental problem. The agreement isn't necessarily linked to the NFT itself. You could also theoretically put the terms of sale in the reference work that's held off-chain, but again, that is something that is not necessarily connected to the NFT itself. It can change over time, and you still have no guarantee that the buyer has read the terms when the sale is consummated. And as you have more and more secondary purchasers and you get further and further away from the initial sale, the problems just get harder and harder to make sure that all of the downstream purchasers saw and assented to all of the contract terms, and to make sure that the prior sellers and the original minter are bound by the same terms to provide the thing that was originally provided when the NFT was minted. And the fundamental question, if you buy an NFT that doesn't have any sale terms whatsoever, what have you purchased? The answer is probably nothing, at least nothing that the law can protect. We'll talk about this later, but one of the off-chain problems with NFTs is that the reference work can change. You can get rug pulled. And if you don't have a contract that says you are entitled to one specific thing, well, the NFT doesn't tell you what the thing was that you were supposed to buy. In a way, an NFT is like a hyperlink, and you can't own a hyperlink. So if you buy an NFT that doesn't have contract terms, it doesn't define what you have purchased, and you aren't familiar with the terms of conditions, and you want to try and enforce that NFT against someone that you purchased it from, I'm afraid to tell you that I think you own about as much as a hyperlink, which is to say you can't own that. Many people claim that NFTs supplant copyright law entirely, and unfortunately that's not even close. NFTs are a product of contract law, extremely fundamental ideas of contract law. And there are real problems when it comes to enforcing those contracts and creating privity between the original minter and downstream purchasers. Now, one of the things that NFTs can do is that they can be attributed with some basic programming, so-called smart contracts. Now, and these smart contracts are basically contracts in the same sense that a microchip is a contract. It's not a legally binding document. It just has a bit of programming to do things when certain conditions are met. And these smart contracts seem to do well when they are based on internet native occurrences and simple transactions, the kind of thing like an escrow account where you don't release funds until certain conditions precedent are met. But these smart contracts, these tiny programs, are not real contracts. They don't bind the downstream purchasers. And in fact, as we've seen, they can break over time. There are no legal rights that are created as a result of the smart contracts themselves. So for better or worse, lawyers exist for a reason, and programmers are really, really bad at planning for contingencies. And they're also really bad at understanding contract law in general. So the bottom line is that NFTs are a product of contract, the terms under which you bought them. So for all of those who purchased in NFTs, I'm sure that you all checked the terms and conditions before you purchased, right? You got terms and conditions, right? And that brings us to copyright, because NFTs do not supplant copyright law, not even close. NFTs are bound by normal, everyday rules of copyright. When you buy an NFT, sometimes you get the copyright, but most of the times you don't. Again, it entirely depends on the original terms of sale related to the NFT. NBA Top Shots, for example, does not give you a copyright in the original video to the NBA. They give you an extremely limited license to use that video in extremely limited places, and nothing more. Some other famous examples where people think they're buying the copyright but aren't include Cryptoads and Bored Ape Yacht Club. With Cryptoads, they basically operate under the Creative Commons Zero license, where if you buy a Cryptoads JPEG, they allow you to do basically whatever you want with them. But again, Cryptoads hangs on to the original copyright. They simply license it to downstream purchasers. Same thing with the Bored Ape Yacht Club. They offer a fairly expansive license, but again, they hold the IP centrally. And you're just simply given a license. You are not buying the copyright associated with the Bored Ape cartoon that you purchased. And with Bored Ape, the license is held off-chain, which means that that license might change over time, and you might never even know about it. And often this has very little to do with copyright at all. If you buy an NBA Top Shot, let's say of a particular clip of something that happened in the NBA, you can't enforce that against someone who is displaying that piece of video somewhere else. And on top of that, the NBA can prevent you from displaying that particular video clip if you're displaying it in a way that conflicts with the license that was purchased through NBA Top Shots, which again is incredibly restrictive. And the issue of copyright is incredibly important because when you're talking about digital art, that's often the only right that the law recognizes. If you don't have the copyright, then you effectively have nothing. And that's important because in the context of NFTs, a lot of the art that is being bought and sold probably doesn't have a copyright at all. It's uncopyrightable. The ultimate irony is that when it comes to digital art that does have a copyright, ironically, the copyright is a scarce resource. There's only one. Sure, you can license it an infinite number of times, or you can assign the copyright, but the copyright itself is inherently scarce. And maybe we never needed to solve the digital scarcity question at all because it was already solved through regular copyright law. Because a lot of the reference art that's associated with an NFT is called generative art. It's art that's created by AI or programmatically through a computer. You might have heard of the Ninth Circuit case, Naruto versus Slater. That is the monkey selfie case, where the courts recognize that only a human can create art that has a copyright. In that particular case, there was a monkey that got a hold of a photographer's camera, took a selfie and the photographer tried to exercise a copyright in that particular piece of artwork. At the same time, PETA said that the monkey owned the copyright to that particular photo, and they intervened to try to exercise the monkey's rights on its behalf. And the court found that no one had a copyright because only humans can have a copyright in art. Only humans can create art that is copyrightable. So by extension, if a machine is deemed to be the author of a work, no one can exercise a copyright in that particular artwork. And in the context of NFTs, there's untold numbers of works that are touted as being created by computers. That's deemed to be a feature, not a bug. And if that's the case, I don't think that there is a copyright there to begin with. No one can exercise any rights associated with that artwork because no human created it. Even with the very famous Bored Ape Yacht Club, it seems to be just a rehashing of the same elements over and over and over again, which I believe were hashed by a computer rather than a person. A person may have created the individual elements once upon a time, but the individual artworks were created by a computer. Now, there are some complicated issues related to copyrights of compilations and works for hire, but there is an argument that some very, very expensive NFTs simply don't have a copyright at all. Now, in fairness to NFTs, in the real world, when you buy real art, you buy a physical painting, it's normal not to buy the copyright associated with that particular painting. When you buy a novel, you are not buying the copyright associated with that novel. So it's not unusual in the art world to not get the copyright associated with a work. And so in some sense, it's normal not to get a copyright associated with digital art. The issue here is that digital art doesn't have a physical token. If you aren't getting the copyright associated with the digital art, you're not really getting anything that is protectable under the law. But of course, in the real world, you actually have a physical thing. And that's associated with a legal doctrine called the first sale doctrine, that when you buy a physical good, whether it is a painting or a pair of Nike shoes, you can basically do whatever you want to that physical good. You don't have necessarily the right to reproduce or otherwise use an image of the thing that you have purchased, but you do have the right to basically do whatever you want with the physical good itself, including selling it to somebody else. Physical works of art are almost inherently scarce as well. A painting can only be painted by a human once. And NFTs are touted as solving the infinite reproducibility problem with digital works, where legally speaking, at least, no NFT can claim to have provenance over an artwork that is itself legally infinitely reproducible. So when it comes to digital art such as JPEGs, if you're not buying the copyright, I'm not sure legally what you are buying. And as a non-legal aside, I know art is inherently subjective and there's no objectivity in art, and claiming that something is good art or bad art is inherently inchoate. But I mean, just look at this stuff. This is bad art. And if you're claiming that this art is inherently worth hundreds of thousands of dollars apart from any speculative value, I don't think you're good at art. So that takes us to consumer protection issues. We've seen that there is a vast gulf between what people think they are getting and what they're actually getting when it comes to NFTs. And these NFTs are widely promoted by a wide variety of different people, including the people that are selling these things and people who are paid to promote them. And it doesn't seem that anyone really knows exactly what they are receiving. Platforms like NBA Top Shots, who you can assume have legions of lawyers, have actually changed a lot of the marketing language that they've used. Historically, they used language like owning a moment, but that probably doesn't line up with the idea of getting an extremely limited IP license to view and display the reference work almost exclusively on the Top Shots platform. Now they use language like scoring in NFT or collecting in NFT, which to me is very, very different than the idea of owning a moment. And it almost goes without saying, but I'll say it anyway, you can't own a moment. That is not a thing that the law recognizes that anyone can own. You might as well try and buy a star in a faraway galaxy. You can't own that. And it seems like there is a huge amount of misperception in terms of what people think they're getting in terms of ownership. And of course, the false promises from the minters are compounding that effect. And whenever you have false promises from sellers and misperceptions of buyers, you run into consumer protection issues. If I was a minter or a seller of NFTs, I'd make darn sure that every single person saw the terms and conditions so that there was no confusion as to what I was selling and what they were buying. But that's just simply not happening in this industry. And while many people would probably try and claim First Amendment protection, the First Amendment does not extend nearly as much to buyers and sellers of goods. When you have commercial sales and commercial speech, the First Amendment doesn't protect nearly as much as you'd think it would. And as we discussed, many NFTs drop without any terms whatsoever. And for those that do have terms, it's not at all clear that those terms travel with downstream purchasers of those NFTs. NFTs are also a product of programming, and as we've seen time and time again, those programs can fail. An NFT can be corrupted, the reference work can be rug pulled, you can change the reference work. Even if you're pointing to an IPFS file, that can change. Who's responsible if the NFT isn't even delivering the things that it was supposed to deliver, if those terms exist? Often NFTs provide the division of royalties and revenue streams, but those often only work if the blockchain is working. You better hope that the blockchain doesn't fork, that the programming works, and that it provides for every single contingency that you can think of, because those things break all the time. And there are all kinds of laws that make sure that consumers are protected by contracts of adhesion. There is the e-Sign Act that governs whether a click-wrap agreement on a website is enforceable, both against the seller and to the buyer. These are effectively the same kinds of issues that any kind of e-commerce website is going to have to deal with. But effectively, every single individual buyer and seller of an NFT have to deal with the same thing. And many people just aren't. Making sure that contract terms are enforceable is a known issue that all websites, whether it's Web 2.0 or Web 3, have to deal with. And you might try and put a contract on OpenSea if that is the marketplace that you are trying to sell your NFT, but right now there's no guarantee that anyone's going to read it. And if no one's reading the contract terms, you've got big issues in terms of enforceability, let alone privity. And the bottom line is that you have to make sure that consumers are affirmatively consenting to the contract terms. And if you can't prove that, that might be your problem. But it also might be the problem of the NFT purchasers. If they want to make sure that third parties are providing off-chain unlocked goods, well, you'd better have a contract that makes sure that they actually provide those things. And then there's all kinds of securities related legal issues. NFTs are being marketed mostly as art or collectibles, but at the same time, there is so much hype and so much speculation, people tout them as incredible investment opportunities, premised on the idea that they will always increase in value. At the moment, it's incredibly unclear, but it's possible that the Securities and Exchange Commission, the SEC, could classify certain NFTs as security. If they are classified as securities, this triggers all kinds of regulatory issues with potential liabilities. And while it's currently unclear, courts will use what's called the Howey test to determine whether these things are securities or not. That stems from a Supreme Court case. Under this test, a transaction is deemed an investment contract if a person, quote, invests his money in a common enterprise and is led to expect profits solely from the efforts of the promoter or a third party. This was a huge problem for the ICO, the initial coin offering boom of 2017, because those initial coin offerings ran afoul of the Howey test and were regulated as securities. Effectively, people offered coins on a blockchain related to some enterprise for a thing that had not yet been created. And as a result, you rarely see initial coin offerings anymore, at least not from companies that are trying to abide by the law. But now, the argument against NFTs as securities is that NFTs are finished products, not investment vehicles that need to be managed. If NFTs appreciate in value, it's through principles like scarcity and just market forces, not because of a third party's effort to enhance the NFT's value. And the SEC's 2019 framework says, quote, price appreciation resulting solely from external market forces such as general inflationary trends or the economy, impacting the supply and demand of an underlying asset generally is not considered profit under the Howey test. So an increase in value alone doesn't make something a security. However, some of the proposed uses of NFTs are a much closer call and would probably be considered securities if push came to shove. Things like royalty payments to artists, especially if the art hasn't been created yet, would be a much closer call. And even apart from securities-related regulation, there seems to be all kinds of just garden variety fraud. The NFT markets are rife with rug pulls and rickrolls, people who are intentionally scamming other people out of hundreds of thousands, if not millions of dollars. Not in the sense that NFTs in general are a scam, but literally these things are actual scams where they're making false promises knowing that they are false and then not providing on the thing that they promise to provide. I mean, that is just good old-fashioned fraud. But don't take my word for it. I turned to the foremost expert in crypto-related scams, CoffeeZilla, to give me a recent salient example.
One example of when an NFT project promised and then didn't deliver on what it said it would was De'Aaron Fox's project called Swipa the Fox. De'Aaron is an NBA player for the Sacramento Kings, and he recently pulled in $1.5 million in NFT sales, in part due to a roadmap where he had promised some pretty extraordinary things which would give these NFTs some real-world utility. For example, one of the perks was going to be a metaverse basketball court, 5 scholarships, charity giveaways, free merch, even tickets to all-star games. These all gave investors the impression that these NFTs might have real-world value and be worth buying. However, right after the money came in, De'Aaron Fox issued a statement saying he was too busy with his NBA career to make all that happen and was quitting the project. No refunds, of course. Apparently, he wasn't too busy to start the NFT, just too busy to deliver on what he promised.
Then, of course, there's all kinds of market manipulations. Many of the high dollar amount transactions related to very high ticket NFTs are not conducted by arm's length transactions. They might be wash sales where an individual sells an NFT to themselves using a sock puppet, or there might be coordination between two different people who agree to pay a high price for something to prop up the price. Because the blockchain is quasi-anonymous, pseudonymous if you want to get technical, it's very easy for people to create sock puppet accounts that they control so that they can show a price history of their NFT being sold for lots and lots of money so that some unsuspecting downstream purchaser thinks, well, if that person paid this much, then I'll pay even more and I'll be able to sell it to somebody else down the line for even more than that. Now, this to me raises garden variety issues of fraud. It's just out and out fraud and market manipulation. It could even be a violation of the Sherman Antitrust Act. This is the kind of anti-competitive behavior that the DOJ and FTC likes to crack down on. And often when you get into price manipulation among several different people, well, then you're getting into criminal liability under the Sherman Act. Maybe there's an infinite supply of greater fools when the prices keep going up, but as soon as any particular NFT crashes and a buyer realizes that there was price manipulation before they purchased their NFT, they might come looking for some heads to roll, and there might be some real civil and criminal liability associated with people who were propping up the prices unfairly. And then there's lots of just pump and dump schemes, people who maybe aren't promoting an out and out scam, but are looking to make a quick buck. And there's right now a proposed class action against people who promoted Ethereum Max. People like Kim Kardashian, Floyd Mayweather, Paul Pierce. They promoted this token on their social media chains. And right now there's a class action because it was clearly a pump and dump scheme. And the Ethereum Max lawsuit doesn't rely on federal securities law. It relies on pretty normal state-based causes of action like unjust enrichment, violations of California's unfair competition law, and the California Consumer Legal Remedies Act. I don't know that we will ever know for certain how many NFTs are sold in wash sales, how many people are trying to drive up the price of these things, but anyone who is manipulating the market here really faces some truly terrifying civil liability and maybe jail time. And those are just the on-chain problems. That takes us to the off-chain problems associated with NFTs. The first of which is you need to make sure that if you're selling an NFT, you have the rights to the reference work. Recently, an NFT minter called Hitpiece purported to issue an NFT related to every song on Spotify's database. So they would effectively take the album artwork and mint an NFT related to the artist and name of the song. It seems like that raises some very truly terrifying issues in terms of Hitpiece not owning any of the rights associated with any of the songs, artists, or album artwork associated with the NFTs that they claim to be making. Now, interestingly, there is a novel issue of copyright here. Since the NFT doesn't contain the musical work itself, there's an open question whether these NFTs violate the musical copyright. I'd argue they probably do, but that's a separate issue. And on top of that, there is no question that minting an NFT related to a band and their song using all of those names and their album work certainly violate the trademark related to this particular band and song, and probably a myriad of other attribution-related legal issues as well. Then there was another music-related NFT project called Streamer.fm that claimed that because you could stream music on Spotify and YouTube, they were somehow allowed to mint these NFTs and restream the music, which is not how any of this works at all. Fundamentally here, clearing the rights and making sure you have the rights to mint the NFT in the first place goes back to old-fashioned, boring concepts of contract and copyright law. NFT and blockchain technology not only doesn't supplant or replace those bedrock principles of law, they often run headlong right into it. And when it comes to this corpus of law and brand new NFTs, NFTs are going to lose. But there's all kinds of minting NFTs without permission. And often you have no way of knowing whether the original minter had the rights and the clearances to mint the NFTs that they are minting. Proponents of NFTs claim that NFTs can prove digital provenance related to works of art. But the truth is, often you have no idea if the original minter has any of the rights associated with the work in the first place. And there's absolutely no way to know except through conducting an investigation completely off-chain. This is actually one of the issues associated with the Quentin Tarantino and Miramax case. In that case, Quentin Tarantino, the director, was trying to mint some NFTs related to the film Pulp Fiction. And it's a complete morass to try and figure this out because Tarantino retained some rights to the screenplay of the movie Pulp Fiction, but Miramax retains almost all of the rights associated with the movie itself. And it's going to take a lot of litigation to figure out who owns what rights and who has the right to make NFTs related to either the screenplay or the movie itself. And good luck if you think the NFT itself is going to prove the answer to either of those questions. Then, of course, there's all kinds of good old-fashioned regulatory risk. A lot of people have explained that an NFT or a blockchain might make perfect sense in the context of, say, real estate title, where having a public, decentralized blockchain of who buys and sells houses could actually be much better than the current system of a centralized title system. But good luck trying to convince a state or municipality to adopt that. And if your blockchain runs into something that's already highly regulated, like real estate title, you can't wave a magic wand and force the government to adopt your technical solution, even if your technical solution has some benefits over the universally adopted system. One of the biggest issues is, as a downstream purchaser, how do you make sure that you can enforce all of the terms against the previous purchasers and the original NFT minter? But the problem also goes the other way as well. If those terms do travel down that chain, let's say that you are a band or a YouTube creator, and as part of your NFT, you issue some sort of unlockable content like a meet and greet with the band. And based on the terms of sale, anyone who ever purchases that particular NFT has the right to enforce a meet and greet against the band. Well, as the seller, are you prepared to offer a meet and greet with every single person who ever purchases that NFT down the line? Because depending on the terms of the sale, you might be obligated to provide that. Otherwise, you might get hit with things like breach of contract or fraud, depending on the value of the thing that you have promised to provide. I was talking to a very large YouTube creator who wanted to create an NFT. I'm not going to name him, but I am going to wish him congratulations when he passes 100 million subscribers in just a little while. And he wanted to offer a video conference with whoever purchased this NFT 24 hours a day, 365 days out of the year. And I suggested to him that maybe that wasn't a good idea unless he liked being woken up in the middle of the night and being forced to provide a video conference with every single person who purchased his NFT. And lo and behold, he didn't go through with it. And I think that was a smart thing. I've seen lots of people claim that there is absolutely no downside to creators creating their own NFTs. On the contrary, there's all kinds of potential pitfalls if you're not smart about these things. And there's things like product liabilities. NFTs break all the time. Who's responsible if the link between the NFT and the reference material breaks? Who's responsible if the blockchain forks and your revenue stream is then cut off? These are sort of bedrock ideas of product liability. On top of which, it's not at all clear from the blockchain itself that the thing isn't functioning. You've got to do an investigation off the blockchain to know if the thing that's on the blockchain is actually working or not. There's been a lot of talk about minting NFTs related to real world goods, creating an NFT related to a house to track who buys and sells the house, creating an NFT related to a car, related to the car itself. But what happens when something happens in the real world that isn't reflected on the blockchain? What happens if the house burns down? What happens if the car gets stolen? Rectifying real world events with things on the blockchain is no easy task and is inherently off-chain. And there are other unintended consequences along with this as well. For example, Alfa Romeo just said that they're going to start offering NFTs related to their cars. And when you take your Alfa Romeo car into being serviced with Alfa Romeo, there will be a history on the blockchain that shows that your car was serviced at such and such a time in such and such a way, and that follows with the car. But one of the problems is what happens if you take your car to a non-authorized dealer? That information won't make it onto the Alfa Romeo blockchain. It's one way that Alfa Romeo might force you to use their walled garden. It'd be like DRM for a car. You'd never be able to take your car to any other service place. Now, I am not a computer programmer. These might be technical problems that will be fixed over time. Already, we're seeing intermediaries like OpenSea interpret the data on blockchain and solve some of the issues when it comes to falsely minted NFTs. But if that's the case, and we need these intermediaries that are off-chain, it raises the question, why would we want Web3? In fact, we can do all of this stuff legally using traditional websites and traditional legal mechanisms. Often the Web3 part of it just makes things worse. Which takes us to the third category of problems with NFTs, which I've called innovation so mundane that no one should care. And the issue here is that there are probably plenty of marginal benefits that NFTs bring to the table for a wide variety of industries. They're just not huge wins that are going to create an enormous amount of wealth for the people with vested interests. It's pretty clear that collectible JPEGs are pretty dumb, and that this is a speculative bubble with untold numbers of non-arm's length transactions, wash sales, and sock puppets. It's pretty clear at this point that at least this first generation of NFTs are creating a speculative bubble that is probably going to burst pretty violently. Collectible JPEGs and other collectible digital pieces of artwork, it's probably not going to last. It's pretty dumb, and I think people will probably get bored with it. It's also filled with all kinds of non-arm's length transactions, wash sales, and sock puppets that are propping up the prices and just waiting for another person to come around and buy the thing that probably isn't worth the sales price. But that being said, there are probably lots of other uses that are more promising. Fractionalized revenue streams, access to unique membership style opportunities, proving certain kinds of provenance, and raising equity. But the thing is, those uses of NFTs are genuine, but they're really just marginal improvements on current technology, if they are indeed improvements at all. And NFT acolytes are claiming NFTs are a grand slam, but it's probably more like a simple walk-on single. These improvements in technology are probably useful, but they're also extremely mundane. The technology at use here probably will form some of the unseen backbone of certain transactions, but it just simply won't be get-rich-quick schemes. It seems likely that the huge market for NFTs as collectibles will probably crash at some point. And when the bubble around JPEGs dies out, what will be left is probably a technology that makes marginal improvements. It's going to create a few millionaires, maybe even billionaires, who find novel and practical uses for this technology, but it's not going to create overnight millionaires for everyone that wants to mint some low-value NFT going forward. And the reason that that is a problem for NFTs is that there are many, many people who have staked their entire reputations as well as their entire finances on the proposition that NFTs have created a completely new industry and that it can create overnight millionaires in anyone. And when people realize that that's not the case, well, the entire industry may evaporate overnight. faster than Beanie Babies. Now, of course, NFTs are heralded as this revolution in creator economics as a way for artists to actually pay what they're worth, but people don't realize that there's real liability and that NFTs could be incredibly dangerous, if not outright terrible for creators. I go into great detail based on my experience as a lawyer, but also my experience as a creator myself. Let's just say there's a reason I haven't minted any NFTs myself. Now, what if I told you that you could watch another LegalEagle video, but this time it's on why NFTs could be dangerous and bad for creators? Well, this full-length companion video does exist, and it is exclusively on Nebula. Because sadly, if I put it on YouTube, it would probably get demonetized, and there's no way you'd ever see it. But Nebula is different. As you've probably heard by now, Nebula is home to tons of exclusive ad-free content, like my first full-length documentary, Bad Law Words Good, a long-form interview with Mark Rober, exclusive videos on legal rights you should definitely use, and anti-SLAPP laws in Kyle Rittenhouse, plus tons more. And all of this exclusive content is only on Nebula, which you can get for free with CuriosityStream. Of course, the reason why all these videos are only available on Nebula is because they just wouldn't work here on YouTube. They'd never be viewed because of the way that the site works. But on the other hand, Nebula is a different platform with no algorithm and without any ads. Because Nebula is a place where we can experiment with content, put things on there that we couldn't put on YouTube. Nebula is a platform for great and unique content made by independent educational creators that you probably already know, like Tom Scott, Thomas Frank, and Thomas Flight, as well as lots of other people not named Tom, like Half is Interesting, Marquez Brownlee, Real Life Lore, Wendover Productions, Mike Boyd, Minute Earth, Neo, Real Engineering, Knowing Better, and so many others. There's tons of exclusive content released multiple times every day. And Nebula is creator owned and operated, and we've been developing like crazy. Nebula now has apps for iOS, Android, Apple TV, Roku, Fire TV, and Android TV. And we're thrilled to be partnering with CuriosityStream because they're the go-to source for the best documentaries and long-form educational content on the internet. They even have an entire section devoted to unsolved mysteries and crimes, so if you like my videos, you'll love the stuff on CuriosityStream. And the best way to get access to Nebula and all of this incredible content is definitely through the amazing CuriosityStream Nebula bundle, with its current sales price of less than $15 for the entire year, which gives you access to both sites. And to be clear, that Nebula subscription is not a trial, it's free for as long as you're a CuriosityStream member. There just isn't a better deal in streaming anywhere, and you get 2 great streaming sites with content you'll actually watch and enjoy. And what's more, signing up will actually help countless independent educational creators beyond just LegalEagle. So sign up right now by clicking on the button that's on screen right now, which will take you directly to curiositystream.com/LegalEagle to sign up. Or you can click on the link that's down below in the description. It's a great way to support educational content and get tons of exclusive content that you'll love. So go watch it right now. Or you can click on this playlist over here with all of my other real law reviews. So click on one of these links, or I'll see you in court. President Trump is big mad at Harvard. I mean, I am too, but for very different reasons. But in retribution for fighting back against the administration, President Trump is trying to prevent any international students from studying at Harvard. But hours after he tried to prevent Harvard from enrolling or continue to enroll international students, a judge stepped in and enjoined it, at least temporarily. Yes, President Trump and DHS Secretary Kristi Noem thought they could deport every international student and teacher at Harvard. But Harvard's conservative lawyers, led by Trump fighters Jenner and Block, marched into court early Friday morning, and a federal district court judge shot down the government's policy before Trump and Noem even had a chance to finish their morning coffee. This one might take the cake as the fastest injunction against the Trump administration, being issued just mere business hours after the initial complaint had been filed. As you may know, President Trump has been targeting Harvard ever since the university openly defied his demands to limit pro-Palestinian activism and end diversity, equity, and inclusion practices. But now Secretary Noem alleges that foreign students and teachers have turned Harvard into a den of anti-Semitism and communism. So she purportedly revoked Harvard University's certification under the Student and Exchange Visitor Program, which I'm just going to call CVIP for short, which is the program which allows universities to admit international students. And although the administration claims that their actions are motivated by students who are Hamas sympathizers, whatever that means, the policy makes no such distinctions. So today we're going to delve into Trump's attack on Harvard's foreign students and explain why a district court quickly put a stop to it. Now, for over 70 years, Harvard has hosted international students under the F1 and J1 visa programs. The F1 visa is for international students, and the J1 visa is for teachers and researchers. Now, to maintain their certification, schools have to adhere to strict record-keeping, reporting, and compliance requirements, and students have to remain enrolled in school full-time to stay in status. But on April 16, 2025, DHS Secretary Kristi Noem sent a records request to Harvard, citing Harvard's alleged failure to condemn anti-Semitism and implying a hostile campus environment. The request demanded broad and vague data about every international student, including whether they had engaged in, quote, illegal activity, made threats, or obstructed the learning environment. Now, Noem's request did not define any of these terms. But according to Harvard's complaint, quote, over the last 12 years, Harvard had received only a handful of requests for information about its F1 visa students. These requests have generally sought straightforward information plainly contemplated by the applicable regulations, such as the student's email, physical address, and phone number about a single student at a time. No prior request has asked for information as broad or as open-ended or covering as many students as the records request. Now, DHS gave Harvard a laughably short 10 business days to comply, threatening that their failure would be treated as, quote, voluntary withdrawal from the F1 program with no appeal allowed. Now, despite the unprecedented scope of the letter, Harvard claims that they complied with the request. On April 30th, Harvard submitted the records outlined by 8 CFR 214.3, including records of coursework and academic transcripts. And on May 14th, it submitted additional information in response to a follow-up request. And in its response letter, Harvard asked the government for the opportunity to cure any alleged non-compliance. And the university contends that DHS cannot unilaterally revoke its CVIB certification without allowing it a chance to address the government's concerns. Now, when Harvard filed its lawsuit, its complaint cites 5 U.S.C. 558C, which states that before revoking a license, the government must give the licensee, quote, notice of the facts or conduct which may warrant the action and an opportunity to demonstrate or achieve compliance with all lawful requirements. Nevertheless, on May 22nd, DHS revoked Harvard's CVIB certification, calling its responses insufficient without providing justification or citing any specific regulation that Harvard violated. Now, Harvard alleges that DHS failed to, quote, follow any of the detailed processes required under the regulations prior to revoking a school's certification. And the lawsuit brings 3 claims against the government. First, Harvard claims that the government violated the First Amendment by retaliating against the university after Harvard refused to adopt the political directives and suppress certain viewpoints. Harvard alleges the government explicitly tied its punitive actions to Harvard's speech and refusal to follow Trump's ideological mandates, such as conducting viewpoint audits and disciplining specific student groups. Now, the second claim is for violating the Fifth Amendment's right to due process. Harvard argues it was denied notice and an opportunity to contest the CVIB revocation, violating procedural due process. DHS allegedly skipped the entire regulatory process outlined in 8 CFR 214.3 and 214.4, which required notice, a formal review, and an opportunity to respond. And the third claim is for violations of the Administrative Procedure Act. Harvard asserts that DHS failed to follow mandatory procedures and did not identify any lawful basis or specific regulatory violation to justify revoking its certification. The government's decision to revoke Harvard's certification was arbitrary, capricious, and unsupported by a reasoned explanation. Now, if you tried to ban international students from a university, you'd probably want a good lawyer. But if you want a great lawyer, let my law firm, the Eagle Team, help. If you've gotten in a car crash, suffered a data breach, especially if you've got a data breach letter saying your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. And it may not surprise you that all 3 of these claims appear to be very strong at first blush. But let's look at how the First Amendment actually operates in higher education. Do they have a leg to stand on? Now, the First Amendment protects individuals from government interference in freedom of speech, religion, press, assembly, and petition. However, it only restricts government actors. That means that Harvard, as a private institution, generally is not directly bound by the First Amendment in the same way that a public university like the University of California is. If Harvard wanted to implement all kinds of restrictions on speech, it probably could. Harvard itself enjoys robust First Amendment protections. That means that Harvard can speak as an institution, take positions on issues, and curate academic environments without government interference, generally speaking. And a school can also generally decide on who to admit, hire, or associate with, as long as it follows anti-discrimination laws. And the Supreme Court interprets the First Amendment to protect academic freedom of institutions and faculty, especially in contexts like scholarly research and teaching. The Supreme Court has held that academic freedom is a, quote, special concern of the First Amendment, and the first major recognition of academic freedom as a First Amendment concern came in the 1957 case of Sweezy versus New Hampshire. Paul Sweezy was an academic and Marxist economist, and during the Red Scare, New Hampshire passed a law empowering the state attorney general to investigate subversive persons. Now, the AG subpoenaed Sweezy to testify about the content of his lectures and political affiliations, and Sweezy testified that he was not a Communist Party member and did not want to overthrow the government. However, he refused to answer other questions such as his personal beliefs about communism, his knowledge of the Progressive Party in New Hampshire and its members, and the content of his lectures. But the state claimed that during a lecture he described, quote, socialism as inevitable in this country, and they asked him if he believed in the theory of dialectical materialism, because people always forget the connection between Hegel and Marx, and whether he advocated Marxism to his students. And when Sweezy refused to answer, he was held in contempt of court. Now, appeals courts upheld his conviction, but the Supreme Court overturned it. The plurality decision struck down the application of the state's Subversive Activities Act because it was overly broad. Then in 1967, the Supreme Court struck down loyalty oaths for public school teachers in Keishian versus Board of Regents. In that case, as a condition of employment, New York state laws required teachers to sign loyalty oaths to refrain from, quote, treasonable or seditious speech or acts. All employees had to certify that they weren't members of the Communist Party. The plaintiff and his colleagues refused to sign the loyalty pledge, and their contracts were terminated. The Supreme Court reversed in favor of Keishian on the basis that the statutes were unconstitutionally vague and overbroad. And the court held that the New York laws had a stifling effect on the, quote, free play of the spirit which all teachers ought especially to cultivate and practice. The majority said, quote, our nation is deeply committed to safeguarding academic freedom, which is of transcendent value to all of us and not merely to the teachers concerned. That freedom is therefore a special concern of the First Amendment, which does not tolerate laws that cast a pall of orthodoxy over the classroom. The vigilant protection of constitutional freedoms is nowhere more vital than the community of American schools. The classroom is particularly the marketplace of ideas. The nation's future depends upon leaders trained through wide exposure to that robust exchange of ideas which discovers truth out of a multitude of tongues rather than through any kind of authoritative selection. And that probably gives you an idea of why Harvard's lawsuit frames its First Amendment claims in the context of academic freedom. The complaint states that, quote, Harvard has long exercised its academic freedom by determining for itself on academic grounds who may teach and what they teach. And Harvard alleges that, quote, the revocation is a blatant violation of the First Amendment, the Due Process Clause, and the Administrative Procedure Act. And Harvard went out of its way in compiling evidence that the administration is retaliating against it for refusing the government's demands. On April 11th, the Trump administration sent a letter to the university seeking full control over Harvard's curricula. Quote, the government demanded, among other things, that Harvard hire a third party to audit the viewpoints of its students, faculty, and staff. Depending on the results of the audit, hire and admit a critical mass of people to achieve the government's preferred level of viewpoint diversity in each department, field, or teaching unit, refuse admission to international students hostile to American values, exclusively empower faculty supportive of the government's action and reduce the power of those opposed, allow the government to review its faculty hires, expel or suspend specific sets of students, disband disfavored student clubs, establish mechanisms for Harvard community members to report on one another and send those reports to the government, which, yeah, seems like an all-out assault on Harvard's First Amendment rights. Then on April 14th, Harvard refused the government's demands, and just hours later, the Trump administration retaliated by freezing more than $2.2 billion in research funding. On April 15th, Trump posted about revoking Harvard's tax-exempt status. Then on April 16th, Noam sent her letter demanding detailed information on all foreign students, and the government issued a press release explaining that Harvard had, quote, allowed anti-American pro-Hamas ideology to poison its campus and classrooms and undermine America's values. On April 24th, Trump's newly weaponized EEOC announced it was investigating Harvard's hiring practices, and on May 13th, the Department of Justice issued a civil investigative demand to the university for allegedly violating the False Claims Act by continuing to maintain affirmative action programs struck down by the Supreme Court. Quote, the surrounding events and defendants' express statements make clear that DHS took these actions not for any valid reason, but purely as punishment for Harvard's speech, its perceived viewpoint, and its refusal to surrender its academic independence or relinquish its constitutional rights. A central tenet of our constitutional system is that the government cannot invoke legal sanctions and other means of coercion to micromanage private speech. And it is bedrock law that the viewpoint-based justifications the government has repeatedly and publicly invoked as a basis for its campaign against Harvard are a particularly egregious form of content discrimination, subject to the strictest scrutiny. The government's actions violate Harvard's rights under the First Amendment several times over. So mere hours after Harvard filed its lawsuit, which itself was only mere hours after the government revoked its certification, Harvard filed a motion for a temporary restraining order asking the court to vacate DHS's revocation of its CVIP certification, enjoin DHS from enforcing the decertification, and restore its ability to enroll and host international students under the F1 and J1 visa programs. Harvard argued that the revocation inflicted serious harm by immediately stripping legal visa status from over 5,000 students, and it arguably barred new students from enrolling for the summer and fall terms. It also dealt a blow to Harvard's finances since most foreign students pay full tuition, which winds up subsidizing American students. And the revocation would also hurt the school's ability to recruit international talent. And surprising no one, the Massachusetts District Court immediately granted the motion. The judge's order enjoins the administration from, quote, implementing, instituting, maintaining, or giving effect to the revocation of plaintiff's CVIP certification, giving any force or effect to the Department of Homeland Security's May 22nd, 2025 revocation notice, and the court set a preliminary injunction hearing for May 29th. So Harvard's international students are safe for now. Still, if you're an aspiring Harvard student, it might be a good idea to scrub your online presence, which is why online privacy is so important. Luckily, there are people out there who can help, like today's sponsor, Incogni. And use my link in the description or the code LegalEagle for an exclusive 60% off discount. Because Incogni removes your personal data from online data brokers by reaching out directly and forcing them to take your personal info down. If these data brokers resist, Incogni will take care of that too because Incogni fights back. And Incogni just launched a new feature called Custom Removals for subscribers to their unlimited plan that I think is really great. It allows you to flag an unlimited number of sites where your data is exposed, and you can have Incogni's privacy experts review and tackle the most uncooperative data brokers and people search sites. Because these data brokers are the reason why in the US you can search your name and find a bunch of websites that'll give anyone your home address, phone number, and extensive history. It's shocking just how easy it is to find all this information. It also might be why you're getting so many spam calls lately, or how someone might steal your identity. But Incogni is a great way to take back control of your data, increase your online privacy, and cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. Now, I've been using Incogni for years. In that time, you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years and is processing dozens of others. If I were to try this myself, it would take hundreds of hours or weeks. So thank you, Incogni, for saving me all that time and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the broker removes your data once, they can collect it again. And Incogni makes sure that your personal information stays off the market for good. So if online privacy is important to you, give Incogni a try. And if you click on the link that's on screen right now or down below, you can try Incogni risk-free for 30 days and get a full refund if you're not into it. And if you do decide to keep it, you'll still get the exclusive 60% off discount, so long as you use my link or the code LegalEagle, all one word, at checkout. So after you sign up for Incogni, click over here for more LegalEagle, or I'll see you in court. Corpus juris, ad hominem tu coque, post hoc ergo propter hoc, quod... I know all of these things, and it's so hard to say. Every once in a while, a genius changes the legal landscape forever. Sometimes that genius isn't even a lawyer. And scholars will look back on history as the days before the Onion filed its Supreme Court brief and the days after. Because we are all changed. Now, it's not surprising because according to the Onion Supreme Court brief, the Onion rose from its humble beginnings as a print newspaper in 1756 and now enjoys a daily readership of 4.3 trillion and has grown into the single most powerful and influential organization in human history. Yes, the Onion has filed its first ever amicus brief, and it started with the top, the US Supreme Court. Its brief immediately took law Twitter by storm, and I've read a lot of briefs in my time, and trust me, they're not all as funny and precise as this one. And people have asked if real lawyers were actually involved in this particular brief. Yes, the authors of this momentous brief, the Onion's head writer Mike Gillis, and the Onion's lawyers of record Stephen J. Van Stempfort and D. Andrew Portinga, who are real people, I actually checked on that, pulled no punches in their brief, writing, quote, "The Onion knows that the federal judiciary is staffed entirely by total Latin dorks. They quote Catullus in the original Latin in chambers. They sweetly whisper stare decisis to their spouses' ears. They mutter cui bono under their breath while picking up after their neighbors' dogs. So the Onion knew that unless it pointed to a suitably Latin rallying cry, its brief would be operating far outside the court's vernacular." I feel so seen. But the question must be asked, is this a great Supreme Court brief or the greatest Supreme Court brief in history? But first we have to ask ourselves, why is the Onion filing a friend of the court brief with the Supreme Court? Well, they're standing up for Anthony Novak, an Ohio man who started mocking his local police department in March of 2016. Novak's Facebook page had the same name, cover photo, and profile photo as the Parma Police Department's official page, but it was designated a community page and didn't have the official blue checkmark verifying it as an official page. Novak's page displayed the satirical slogan, "We know crime." Now, Parma is Cleveland, Ohio's biggest suburb, and it has long had a reputation for being just a little bit extra. And by that, I mean it has a well-documented problem with racism. In the 1970s, the Justice Department concluded that Parma's near-manic growth was a classic example of white flight. The DOJ found that the city of Parma engaged in a pattern and practice of racial discrimination in housing in violation of the Fair Housing Act of 1968, and the city didn't settle with the DOJ until 1998. The Parma Police Department has been cited for refusing to hire minority police officers. Cleveland is 51% black. Its largest suburb is still less than 5% black. And I'll note parenthetically that one of the members of Team LegalEagle is from Cleveland and informs me that the Parma police are notorious for prosecuting drivers for driving while black. Now, legendary public access host Goulardi, father of director Paul Thomas Anderson, relentlessly mocked Parma for decades. Anthony Novak clearly knew this history when he set out to mock the local cops. As Cleveland Magazine once said, quote, "Everyone in the country makes fun of Cleveland and everyone in Cleveland makes fun of Parma." Now, Novak's page was up for 6 hours, and during that time it published 6 satirical posts. The first was an apology for, quote, "failing to inform the public about an armed robbery of a Subway sandwich shop by a white man while requesting information to, quote, bring to justice an African-American woman who was loitering in front of the shop during the robbery. Novak then published a fake announcement that new police officers would be recruited based on a, quote, 15-question multiple-choice definition test followed by a hearing test, and strongly encouraged minorities to not apply. He followed that up with an update about a pedophile reform event, promising that anyone who made it through the stations would be removed from the sex offender registry and accepted as an honorary police officer. Now, by now, you are probably thinking that surely everyone who saw these pages knew it was a parody and, of course, was protected by the First Amendment. But that's not how the Parma police saw it. They got a few phone calls from confused citizens. They immediately posted a warning on the police department's real page, letting people know that the other page was fake and that the department was investigating. The comments to the notice reveal that most citizens understood what was happening. Now, Novak thought it would be funny to post the police notice on his page verbatim, so that's what he did. Officer Kevin Riley didn't like that, and so he went on the local news where he said that the cops were launching an investigation into the page's owner. Riley described the page as, quote,
but frankly, they're crude, they're demeaning, and they're very inflammatory. Our concern right now is public safety.
Now, as legally idiotic as those statements were, Riley's comments did prompt Novak to take his page down, but the Parma officials did not let up. Instead, the police subpoenaed Facebook to unmask Novak. The page wasn't even up by the time that they discovered Novak's identity. Now, once they knew it was Novak, they consulted with prosecutor Timothy Dobek. Dobek and the officers searched for a crime to fit the situation and ultimately landed on Ohio Revised Code section 2909.04b, a felony statute prohibiting the knowing, quote, use of any computer to disrupt, interrupt, or impair the functions of any police operation. Now, how did Novak disrupt the police department? His parody caused 11 people to call up the station in confusion. But that was enough for a local magistrate who found that the cops had probable cause to search Novak's house. The police then conducted a SWAT raid on Novak's home, confiscating his gaming consoles, computers, and tablets. Police arrested Novak and threw him in jail for 4 days. Detective Thomas Connor told the grand jury that the callers, quote, honest to God, actually believed the page was real. The grand jury indicted Novak for disrupting public services, a 4th-degree felony that carried a maximum penalty of 18 months in prison. But not surprisingly, later, during a deposition, Connor admitted that none of the callers thought the parody Facebook page was real, but the damage was done. The city continues to insist to this day that 10 of those calls wasted precious dispatch time. But let's be real. Parma dispatchers probably get more useless phone calls when Rudy Strudel runs out of donuts on Packy Day. I guess that's a Cleveland joke. Now, Novak stood trial, and lucky for him, the jury acquitted him. And after he was acquitted, he then sued the city of Parma, the police department, and the police officers for violating his civil rights, because that's exactly what they did. The police officers, not surprisingly, raised qualified immunity as a defense. Now, I've talked about qualified immunity in the past, but here's a recap of this judicially invented doctrine. Qualified immunity protects state officials from being held accountable on a federal level for violating a person's constitutional rights. Under this doctrine, an officer or state actor is immune from civil liability if a court has not previously stated that the officer's act was unconstitutional in a prior court decision. It's an idea that if there isn't a court decision on this type of constitutional violation, then they don't have notice that they were violating someone's constitutional rights. Now, qualified immunity only allows lawsuits to move forward if state officials violated a, quote, clearly established statutory or constitutional right. And when determining whether or not a right was clearly established, courts consider whether a hypothetical reasonable officer would have known that the defendant's conduct violated the plaintiff's rights. What started as a way to ensure that officials were not held liable for things that they had no way of knowing were unconstitutional has now become really a serious impediment for holding police officers accountable. The Federal District Court for Northern Ohio denied the Parma officer's motion for qualified immunity, but the Sixth Circuit eventually overturned that decision. The court held it was not clearly established that Novak's copying of the department's notice onto his page and the deletion of user comments were protected speech. Under the disruption statute, quote, the officers could reasonably believe that some of Novak's Facebook activity was not parody, not protected, and fair grounds for probable cause. The Sixth Circuit put special value on the fact that a prosecutor and magistrate agreed that there was probable cause that Novak violated the statute. Now, with that somewhat depressing background in mind, we can turn to how in the world does this involve The Onion? Well, when someone files an amicus brief, they have to start by stating why they have an interest in the case that the court should consider. So the brief starts out by discussing the interests of the amicus, the friend of the court, in this case, The Onion. Quote, The Onion is the world's leading news publication, offering highly acclaimed, universally revered coverage of breaking national, international, and local news events. Quote, "The Onion's keen, fact-driven reportage has been cited favorably by one or more local courts, as well as Iran and the Chinese state-run media." Now, I love this part because it goes to the heart of what makes good parody. The ability of the satirist to actually make people think it might be real. And The Onion has tricked many people into reporting its stories as fact. And back in 2012, Iran's Fars news agency published a story claiming that a Gallup poll found that rural white Americans preferred Iranian President Mahmoud Ahmadinejad over President Barack Obama. Although that feels like it might have been true, unfortunately Ahmadinejad was ineligible for US presidency, so we'll never know if his stance about women covering their hair would have gained traction in rural Indiana, though I worry that it would. Chinese state media also thought that The Onion's story declaring Kim Jong-un the sexiest man alive was real. The Onion wrote that Kim was, quote, "blessed with an air of power that masks an unmistakably cute, cuddly side." Kim made this newspaper's editorial board swoon with his impeccable fashion sense, short hairstyle, and of course that famous smile. Well, look, when you put it that way, it's easy to see why the 45th president had such a crush. Now, the Onion brief also points out that it has a good track record of predicting future events. Quote, "One such coup was the Onion's scoop revealing that a former president kept nuclear secrets strewn around his beach home's basement 3 years before it even happened." Fact check, true. Now, The Onion really did write a story in 2017 about the nuclear briefcase being left behind at Mar-a-Lago. Noting that it had already been there for almost 2 weeks, Mar-a-Lago assistant manager Chris Mahoney reportedly wondered if anyone was coming to collect the nuclear briefcase from the club's lost and found. Anyway, The Onion filed this brief to protect the rights of parody creators who, as a class, would prefer not to be arrested for being funny. Quote, "The Onion files this brief to protect its continued ability to create fiction that may ultimately merge into reality. As the Globe's premier parodists, The Onion's writers also have a self-serving interest in preventing political authorities from imprisoning humorists. This brief is submitted in the interest of at least mitigating their future punishment." And the brief zeroes in on the Sixth Circuit's holding that a parodist would not be protected unless they let the audience in on the joke by warning them that their parody is not true. The Onion notes that, quote, "Some forms of comedy don't work unless the comedian is able to tell the joke with a straight face. Parody is the quintessential example. Parodists intentionally inhabit the rhetorical form of their target in order to exaggerate or implode it, and by doing so demonstrate the target's illogic or absurdity." Now, the hilarity of the brief is an example of the thing it seeks to protect, an ultra-serious take on a real thing that by its nature will fool some people. Or as The Onion's lawyers put it, quote, "For parody to work, it has to plausibly mimic the original." And as The Onion points out in its brief, quote, "Tu stultus es, you are dumb." These Latin words have been The Onion's motto and guiding light since it was founded in 1988 as America's finest news source, leading its writers toward the paper's singular purpose of pointing out that its readers are deeply gullible people. And they're not just crapping on their own audience. They're making an important point that, quote, "tricking readers into believing that they're seeing a serious rendering of some specific form, a pop song lyric, a newspaper article, a police beat, and then allowing them to laugh at their own gullibility when they realize that they've fallen victim to one of the oldest tricks in the history of rhetoric. And despite the literal falsity of parody and satire, it literally has to be false to work. It enjoys First Amendment protection, as it should. And when assessing whether satirical speech is defamation, the courts consider what a reasonable reader would have understood the author to have said, not the literal meaning of the words. And the capacity to fool the audience is essential. So in other words, a person, Billy, no, you can't be up here. So in other words, a person doesn't have to publish a disclaimer that the writing is fake. That would ruin the joke. Imagine how it would have ruined the punchline of Jonathan Swift's A Modest Proposal, which argued with a straight face that the starving Irish should just eat their own babies. And if you're worried about The Onion being humble and comparing itself to Jonathan Swift, well, you don't need to be. They write, quote, "To be clear, The Onion is not trying to compare itself to Jonathan Swift. Its writers are far more talented, and their output will be read long after that hack Swift's has been lost to the sands of time. Still, The Onion and its writers share with Swift the common goal of replicating a form precisely in order to critique it from within." And as The Onion points out, Swift's goals was the same, to replicate the form, the boring economic paper, in order to critique it from within. And that's why the full title of Swift's paper was A Modest Proposal for Preventing the Children of Poor People from Being a Burthen to Their Parents or Country and for Making Them Beneficial to the Public. And The Onion writers do this every day to hilarious effect. The brief points to an Onion article titled, quote, "The Supreme Court Rules, Supreme Court Rules," which is meant to mimic the form of the Associated Press. It starts with the sentence, "In a landmark decision Monday, the United States Supreme Court ruled 8-1 that it rules. And The Onion follows the Associated Press form straight through into the article. It says, quote, Justice Anthony Kennedy, writing on behalf of the majority, noted that, quote, while the U.S. Constitution guarantees equality of power among the executive, legislative, and judicial branches, it most definitely does not guarantee equality of coolness. And in this regard, the judicial branch kicks that which can be construed as total and complete ass. So the power of the parody arises from that dissonance into which the reader has been drawn. And The Onion's brief argues that because parody mimics the real thing, it has even more power to critique the real thing. Quote, parodists can take apart an authoritarian cult of personality, point out the rhetorical tricks that politicians use to mislead their constituents, and even undercut a government's institutions' real-world attempts at propaganda. For The Onion, this has worked time and time again, since its articles tend to expose leaders who have no ability to distinguish fact from fiction. The brief singles out one of them, Republican Congressman John Fleming, who, quote, believed that he needed to warn his constituents of a dangerous escalation of the pro-choice movement after reading The Onion's headline, Planned Parenthood opens $8 billion abortionplex. Of course, Yelp reviewers got in on the gag and reviewed the fake Kansas abortionplex, which convinced other readers that this was a real thing and, quote, we taxpayers were paying for it. The legendary abortionplex story is still fooling people in 2022. And although the brief tongue-in-cheek called Onion readers stupid, it backtracks on that claim in explaining the mental capacity of reasonable readers who, quote, do not need to be told explicitly what they have no serious trouble figuring out for themselves. And the brief notes that the Supreme Court has already indicated that disclaimers aren't needed. They refer to a footnote of the opinion of Campbell versus Acuff Rose, which of course was a very famous fair use case where the dispute was about whether the rap group 2 Live Crew had a right to publish a parody of Roy Orbison's Pretty Woman. And in that case, the court said that 2 Live Crew need not label their whole album or even the song a parody in order to claim fair use protection, nor should 2 Live Crew be penalized for this being its first parodic essay. Parody serves its goals whether labeled or not, and there's no reason to require parody to state the obvious, or even the reasonably perceived. And The Onion argues convincingly that the Sixth Circuit's holding is contrary to the case law. The court ruled that the Parma cops, quote, could reasonably believe that some of Novak's Facebook activity was not parody, primarily because Mr. Novak deleted comments that made clear the page was fake. But the brief argues that the lack of explicit disclaimer makes no difference to whether a reasonable reader would discern that this speech was parody. And The Onion takes issue with the Sixth Circuit's view that the search warrant insulates the police from liability, since other authority figures also shared the same wrong-headed view of free speech. Quote, this was not a close call on the facts. Mr. Novak's spoof Facebook post advertised that the Parma Police Department was hosting a pedophile reform event in which successful participants could be removed from the sex offender registry and become honorary members of the department after completing puzzles and quizzes. That the department had discovered an experimental technique for abortions and would be providing them to teens for free in a police van, that the department was soliciting job applicants but that minorities were, quote, strongly encouraged not to apply, and that the department was banning city residents from feeding homeless people in, quote, an attempt to have the homeless population eventually leave our city due to starvation. So yeah, you'd have to be pretty dumb to think that the Facebook posts were real and also criminal. Novak can't help it if a magistrate judge and city attorney are closer to the lowest common denominator than the average reasonable reader. And The Onion also argues that parodists should not be prosecuted for telling jokes. Now, this seems self-explanatory, so the Onion lawyers crafted a couple paragraphs just to keep your attention. Quote, this is the 15th page of a convoluted legal filing intended to deconstruct the societal implications of parody, so the reader's attention is almost certainly wandering. That's understandable. So here's a paragraph of gripping legal analysis to ensure that every jurist who reads this brief is appropriately impressed by the logic of its argument and the lucidity of its prose. Bona vacantia, de bonus asportatus, writ of certiorari, de minimis, jus ascrescendi, forum non conveniens, corpus juris, ad hominem tu coque, post hoc ergo propter hoc, quod, I know all of these things, it's so hard to say, quod est demonstratum, actus reus, scandulum magnatum, pactum reservati domini. See what happened? This brief itself went from a discussion of parody's function and the quite serious historical and legal arguments in favor of strong protections for parodic speech to a curveball mocking the way legalese can be both impenetrably boring and belie the hollowness of a legal position. That's the setup and punchline idea again. It would not have worked quite as well if this brief had said the following. Hello there, reader. We're about to write an amicus brief about the value of parody. Buckle up because we're going to be doing some fairly outre things, including commenting on this text form itself. So yeah, it's not good to punish funny people for saying funny things, even if those things may be offensive. And The Onion promises to, quote, continue its socially valuable role bringing the disinfectant of sunlight into the halls of power, and it would vastly prefer that sunlight not be measured out to its writers in 15-minute increments in an exercise yard. And this YouTube channel agrees. Now, normally a lawyer's conclusion is a pretty dry summary of what they want the court to do, but here The Onion aims high once again. Quote, the petition for certiorari should be granted, the rights of the people vindicated, and various historical wrongs remedied. The Onion would welcome any of the three, particularly the first. So what happens next? Well, the Supreme Court will decide whether to take Novak's case or not, and potentially overturn the Sixth Circuit's decision. If it does not, then the Sixth Circuit decision remains good law, despite it being bad law. But you'll be able to read all about the Supreme Court's next decision in today's sponsor, Morning Brew, because that's my favorite way to catch up with pop culture and the news. In fact, you could have already learned about The Onion's brief because they covered it and I read it in my email. I've actually been subscribed to Morning Brew for forever. It's one of my absolute favorite newsletters, and I'm thrilled to tell you why. Because Morning Brew, if you didn't know already, is a free daily newsletter delivered Monday through Sunday. It gets you up to speed on business, finance, tech, and law in just 5 minutes, and provides a fantastic quick summary of the most important issues while being witty, irreverent, and informative. And did I mention it's completely free? This week I learned all about how Elon Musk actually bought Twitter for real this time, how Kanye West was getting denounced by everyone, and why Matt Damon killed everyone's investment returns. It's basically exactly the mix of news that I'm actually interested in, and stuff that I didn't even know I wanted to know about. And it's all written in a hilarious style. Morning Brew is one of the few emails that I actually open every day. So LegalEagles, this one is a complete no-brainer. Morning Brew is completely free and it takes less than 15 seconds to subscribe. Just click on the link that's on screen right now or in the description to get Morning Brew for free. And not only will you get a newsletter that you'll actually read, you'll actually help out this channel too. So click on the link below to get Morning Brew right away. And after you sign up, you should click over here on this playlist to watch more LegalEagle, or I'll see you in court. Alec Murdaugh convicted after he testified in his own defense. Yeah, the Fifth Amendment exists for a very good reason, and District Attorney Scowell will explain why.
As the trial drew to a close, Los Angeles area double murder expert O.J. Simpson predicted that the Alec Murdaugh jury would acquit the Low Country lawyer of double murder. It turns out that Simpson's powers of prognostication don't really work for murders he wasn't directly involved in.
It wouldn't surprise me in the least if this guy beats this case.
The Juice was wise enough not to testify in his own criminal trial, whereas Murdaugh thought that testifying in his own defense might lead to an acquittal. It's easy to see how he made that mistake. Murdaugh men have been amongst the most prominent lawyers in Hampton County, South Carolina for nearly 100 years. So before I explain why the Murdaugh Hail Mary play didn't work, let's dig into the background of this disturbing case because it is truly bonkers. Lawyers from the Murdaugh family held the solicitor position in South Carolina's 14th Judicial Circuit for 87 years. In South Carolina, a solicitor is an elected official who serves as the chief prosecutor for a judicial district. A judicial district usually covers multiple counties. It's basically a district attorney, but with a seersucker suit and a southern drawl. Randolph Murdaugh Sr. was elected solicitor in 1920 and served until he was killed by a freight train in 1940. Now, some people suspected that the freight train incident was a suicide because no one could figure out why Randolph's car stalled on the tracks, but Murdaugh Sr. was succeeded by his son, Randolph Murdaugh Jr., known as Buster, who held the position for 46 years from 1940 to 1986. During Buster's long tenure, the Murdaugh family's private law firm flourished in the small town of Hampton, population 2,000, because of a unique South Carolina law that allowed people to file lawsuits against the railroad in any county in the state. The Murdaugh firm is referred to as the house that CSX built because they won so much money suing the railroads. Buster was known as a win-at-all-costs prosecutor. The South Carolina Supreme Court reprimanded Buster several times for improper jury arguments during death penalty cases. On 2 separate occasions, 20 years apart, he told jurors that if they didn't impose the death penalty on a criminal defendant, he would use his power as solicitor to release other rapists into the community. Yes, you heard that right. It's hard to imagine a worse thing a prosecutor could say in court, but I'm sure prosecutors have. It's fair to assume that the citizens of the 14th Judicial Circuit just might be intimidated by a man who threatened to turn rapists loose as revenge. When Buster was done, Buster's son, Randolph Murdaugh III, was elected solicitor and served until 2005. Now we've come full circle. Alex Murdaugh, the now convicted murderer, is Randolph III's son. Alex Murdaugh worked in the family law firm and also volunteered as an assistant solicitor. Alex continued his work with the solicitor's office until he himself was indicted for stealing from his clients and partners in 2022. Yeah, we're gonna get there. So here's a question. Are the Murdaughs corrupt? Well, there are open investigations into two separate suspicious deaths that are linked to the family. In 2015, a high school student, Stephen Smith, was found dead in the middle of a Hampton County road. There were no tire marks or debris that would suggest a vehicle crash. At least one highway patrol investigator and the county coroner ruled the death a homicide, suggesting that the body was dumped on the road. A pathologist, however, concluded that Smith was likely struck by a passing vehicle's side mirror. Alex's oldest son, Buster, named for his grandfather, is mentioned dozens of times in the 2015 investigation reports. Rumors swirled locally that Buster had been in a relationship with Smith. Alex and his brother Randy visited the scene and were seen going right through crime scene tape. The South Carolina State Law Enforcement Division reopened the investigation into Smith's death after officers found new evidence during their recent investigations into Alex Murdaugh.
Stephen Smith was killed on Sandy Run Road back in July of 2015. Investigators say his death was originally listed as a result of a hit and run. But his mother has many questions about that ruling. Now the South Carolina Department of Law Enforcement tells WSAV that information from the Murdaugh investigation has led them to reopen Smith's case. They would not say what evidence led to that decision or whether the Murdaugh family was involved in any way.
The second investigation. In 2018, Alex's housekeeper, Gloria Satterfield, allegedly tripped over Alex's dogs and fell down the steps of the Murdaugh family's hunting lodge. Alex was the only witness. After she died from her injuries, Alex told Satterfield's sons to sue him for insurance money. Murdaugh referred the sons to his college roommate, lawyer Corey Fleming. Murdaugh and Fleming collaborated on the insurance settlement, but never told the brothers that they had in fact collected on two settlements, one for more than $500,000 and another for $3.8 million. Murdaugh knew that one of the brothers, Brian, was mentally impaired and living on an annual salary of $14,000. Yet he watched as a bank foreclosed on Brian's trailer, knowing that a check from Lloyd's of London had already been deposited into Alex's own bank account. Murdaugh later admitted to stealing over $4 million from the Satterfields. When a reporter uncovered the Satterfield settlement, investigators started looking for other irregularities. They found that Murdaugh was ripping clients off left and right. Alex Murdaugh's empire of lies started to unravel in 2019. Alex and his wife Maggie had two sons, Paul and Buster. On the night of February 23, 2019, Paul Murdaugh and his 5 friends spent the night partying on Paul's boat. All 6 of them were underage. Paul's friends called him Timmy when he was drunk because he seemed to have a vicious alter ego when he was wasted. Witnesses say that Paul drove the boat for most of the night, except for a few minutes when Connor Cook had to take over because Paul was arguing with his girlfriend Megan Dowdy. Paul's friends say he assaulted Megan. The boat later crashed into a piling and they were all thrown from the boat. Everyone survived except for one, Mallory Beach, who was found dead a week later. After the crash, Alex visited Connor Cook in the hospital. Alex tried to convince Connor that Connor had been driving the boat, not Paul. Randolph Murdaugh III, the former solicitor, arrived at the hospital and stopped police from questioning his grandson. Alex and his wife Maggie traipsed through the crime scene. Eventually, Paul was charged with 2 counts of boating under the influence with great bodily injury and 1 count of boating under the influence causing death. Paul Murdaugh pleaded not guilty and hired a state senator who served on the Judiciary Committee to prepare his defense. But Paul never stood trial because he was murdered alongside his mother on June 7, 2021. June 7th was the date when many things in Alex Murdaugh's life came to a head. Jeannie Seckinger, the chief financial officer at Murdaugh's law firm, confronted him about money that she believed he had stolen from the firm. During the conversation, Alex received a phone call that his father's health had taken a turn for the worse and that he was dying in a Savannah hospital. Seckinger stopped her questions so he could go deal with his father, but a short time later she realized Alex remained in the office.
That check never even came through our books. He stole it, endorsed it, and put it in his Bank of America account, and we found a copy of it on his desk.
He asked her about his 401k balances, which he was worried about producing in the Beach family's wrongful death lawsuit. A hearing was scheduled in that lawsuit that could have compelled discovery of Alex's assets. The Beach family's lawyer said he planned to sue Alex and Maggie personally because they allegedly kept a beer refrigerator at the hunting lodge and underage kids were free to drink up. Given the scale of Alex's financial crimes, discovery of his assets would have revealed years of Murdaugh's criminality. Later that same night, Alex allegedly found Paul and Maggie dead outside the kennels at the Murdaugh's sprawling hunting estate. Alex called 911 shortly after 10 o'clock p.m. He told police that he had just returned home after spending most of the evening out. Police concluded that Paul had been shot at close range twice with a shotgun, and Maggie had been shot with a semi-automatic rifle. The murder weapons have never been recovered. A firearms expert said casings found near Maggie's body were from a rifle round called .300 Blackout. After the murders, Alex told his law partners that he screwed up and would pay back some of the money he had stolen. But by September 3rd, the firm had found more financial irregularities. Later that same day, the partners confronted Alex, and he agreed to resign. The partners, including Alex's brother Randy, agreed to wait until September 6th to announce the resignation. But the next day, on September 4th, Alex's friend Chris Wilson confronted him as well. See, Alex owed Wilson $200,000 after lying to him about a legal settlement. So Alex admitted to stealing from Chris and blamed his behavior on an opioid addiction. And then hours later, that same day after that conversation with Chris, Alex was shot in the head. Yes, seriously. Does this seem like a far-fetched Netflix series yet? On September 4th, Alex Murdaugh called 911 and reported that while he was pulled over on the side of a road with a flat tire, someone had shot him.
I got a flat tire, and I stopped, and somebody stopped to help me. And when I turned my back, they tried to shoot me.
Oh, okay. Were you shot?
Yes, but I mean, I'm okay.
Alex later admitted that he hired his cousin Eddie to shoot him, so Alex's remaining son Buster could collect on a $10 million life insurance policy. But apparently cousin Eddie wasn't up to the job because the gunshot wound was just a graze that temporarily blinded Alex. Eddie would also turn out to be Alex's oxycodone dealer. Alex later admitted that he stole from his law partners and clients to fund his addiction to painkillers. According to Alex, on some days, he was taking up to 60 oxycodone pills. So here's the house of cards the prosecutors were trying to knock down. A very influential family headed by a man with an insatiable appetite for pills. The double murder of Maggie and Paul, who were mowed down on Murdaugh family property, the suicide for hire insurance fraud scheme, and, oh yeah, how could we forget, 99 additional charges by the state attorney general for embezzlement, money laundering, and tax fraud. First was the trial for the murders of Paul and Maggie. The trial was fittingly in South Carolina's 14th Judicial Circuit, the very same circuit for which his family had supplied 3 generations of solicitors. The prosecution really wanted to use the suicide for hire plot to demonstrate that Alex had a propensity for violent schemes. As the prosecutor said, when the hounds are at the door, when Hannibal is at the gates for Alex Murdaugh, violence happens. The judge initially ruled that this incident was off limits for the criminal trial. However, during the trial, the defense asked a witness about whether it was possible that drug gangs killed Paul and Maggie. The judge then reversed himself, ruling that the questions opened the door to prosecutors introducing evidence about Alex and cousin Eddie, since Alex was admittedly associated with a drug dealer. The trial's biggest bombshell was an unsent Snapchat video recovered from Paul's phone. Alex told police he had last seen his son and wife 90 minutes before he found their bodies. He said Maggie and Paul were down at the kennels checking on the dogs. So he took a nap, watched TV, then called and left Maggie a message saying he was going to go check on his mother. Alex visited his mother and then arrived at the kennels around 10, where he found them dead. He repeatedly denied being at the kennels before he found the bodies. As it turns out, Paul filmed a Snapchat video just minutes before he was killed, showing a Labrador retriever wagging its tail. He apparently intended to send the video to his friend Rogan Gibson, whose chocolate lab was staying at the Murdaugh kennels. Several witnesses testified that they could hear Alex's voice in the background of the video.
Hey, he's got a bird in his mouth.
Did the Snapchat video influence Alex's decision to testify on his own behalf? Almost certainly yes. The very first thing Alex did on the witness stand was fess up that he lied about being at the kennels. Alex admitted it was his voice on the video.
Were you in fact at the kennels at 8:44 p.m. on the night Maggie and Paul were murdered?
I was.
Did you lie to SLED Agent Owen and Deputy Laura Rutland on the night of June 7th?
I did lie to them, and I'm so sorry that I did.
Other than lying to them about going to the kennel, I was very cooperative in every aspect of this investigation. Very cooperative, except for maybe the most important fact of all, that you were at the murder scene with the victims just minutes before they died, Prosecutor Waters said. Uh-oh. This admission was just the tip of the iceberg that Alex was about to hit. In every criminal trial, the defendant has a constitutional right to testify or to remain silent. The right to remain silent during a criminal trial means that the jury is legally prohibited from taking a defendant's choice not to testify into account when deciding his or her guilt. The prosecution can't refer to the defendant's decision not to testify as an indicator of guilt. Testifying allows the defendant to tell his own story, but he doesn't get to do it unmediated. When a defendant chooses to testify, the prosecutor gets to cross-examine that defendant. It is rarely a comfortable experience for the defendant, and prosecutors love it. A defendant's testimony opens the door to impeachment. Impeachment is just attacking someone's credibility. Impeachment can happen in a lot of ways. For example, being biased or prior inconsistent statements and past criminal convictions. When a person doesn't have a criminal record to worry about or hasn't made any inconsistent statements, then testifying could be a safer proposition. Emphasis on the could be, because it's not easy to face cross-examination under any circumstances. Even a defendant with no skeletons in the closet can be tripped up. We've seen some high-profile defendants decide to testify in their own defense to mixed results. Self-defense cases often lend themselves to a defendant's testimony. In those cases, there has to be some evidence that the defendant perceived imminent danger of physical injury, and sometimes it can be hard to show that without the defendant's testimony. Kyle Rittenhouse testified that under the circumstances as he perceived them, he didn't have a choice other than to use the amount of force that he did. Rittenhouse stood up fairly well under cross-examination, and at just 18 years old, he really didn't have much in the way of a criminal history or other impeachable matters. In contrast, Elizabeth Holmes was on trial for defrauding patients, doctors, and investors by lying to them about Theranos' technology and business relationships. The subject of her trial was whether she spent years knowingly making false claims. Holmes had already given testimony under oath in civil suits and government investigations, which made testifying a dicier proposition. During her criminal trial, she blamed other people and claimed that her lies were just misunderstandings. When she said she couldn't remember the details of a certain topic, the prosecutor essentially impeached her with testimony that she had previously given to the SEC where she certainly did remember. And the jury, of course, convicted her. So back to Alex Murdaugh. He's a lawyer with experience prosecuting and defending criminal cases, and also probably a narcissist. So it's not surprising that he thought he could handle himself on the witness stand. However, a defendant's credibility is absolutely crucial, which is why prosecutors try so hard to impeach. If the jury thinks the defendant is a liar, things go south quickly. And it seems like that's exactly what happened to Alex. Alex claimed that he told one whopper about his alibi, that he wasn't at the kennels before the murders. But other than that, he was cooperative with investigators and truthful in his testimony. But Prosecutor Creighton Waters was able to show a pattern of duplicity. Quote, "The second you're confronted with facts you can't deny, you immediately come up with a new lie," he said. The prosecutor was able to call out numerous lies by Murdaugh. For example, when Murdaugh's plan to get murdered by Cousin Eddie failed, he quickly created an elaborate story. While he was recovering in the hospital, he brought in a sketch artist to create a fake picture of the non-existent stranger who allegedly shot him. When Alex's brother Randy overheard Alex trying to bribe a nurse to let him use her phone, he thought it was suspicious. And brother Randy called the police and the story began to unravel.
With a SLED sketch artist and spent a period of time with her going forward and creating an image of the supposed assailant.
I did sit down with her. I was in the hospital and they came in, sat down with me, asked me a bunch of questions. I answered their questions, and
yes, you did. You sat there.
It came up with a composite. Yes, sir.
sat there and answered their questions just as effortlessly and convincingly as you've been trying to do for the past 2 days. Isn't that correct?
No, sir, that's not true.
The prosecutor also showed that Alex would say whatever was necessary to help his own case. Alex told the jury that when he found the bodies, he didn't check their pulses before calling 911 because there wasn't enough time. But in an earlier statement to police, Alex claimed that when he found his family murdered, he checked their pulses and then dialed 911. The prosecutor's reconstruction of the timeline revealed that only 20 seconds passed between the time Murdaugh parked his car at the kennels and when he called 911. So as soon as Alex was confronted with this seemingly impossible timeline, he came up with a new story. The prosecutor asked Alex if he killed his wife and child. When asked if he knew who did it, Alex also said no. But in an earlier interview with investigators, Alex had actually implicated his groundskeeper. He also told the jury that someone angry about the death of Mallory Beach committed the murders. These inconsistencies undermined Alex's credibility. Then there's the mess with Alex's financial crimes. The prosecution argued that Alex's financial crimes couldn't be separated from the murders because exposure of his vast financial crimes was one of the motives for killing Maggie and Paul. The defense countered that the financial crimes had nothing to do with the murders and that the prosecution lacked proof that the two were related in any way. During direct examination, Alex explained that he committed a lot of financial crimes because of his drug addiction. Alex's lawyers portrayed the admission of wrongdoing as a willingness to come clean. They argued that a person who admits to lying isn't necessarily a person who commits violence, which is true in a general sense. However, was it a good strategy in this particular case to admit to years of financial fraud? Not really. On cross-examination, the prosecution scored several key points. Prosecutor Waters held up a stack of papers relating to clients whom Alex stole from. Quote, "Every single one of these, you had to sit down and look someone in the eye and convince them that you were on their side when you were not, correct?"
Do you remember it, even one of them?
If you ask me questions, but I can't remember sitting down with Dion.
Alex's response? "What I admit is I misled them. I did wrong and that I stole their money." What Prosecutor Waters was getting at was this. Ladies and gentlemen of the jury, Alex Murdaugh is sitting there and looking at you in the eye trying to convince you of something, but you shouldn't believe him. Just look at how he lied in the past. Moreover, Alex testified that all of his financial bad deeds were caused by his drug habit, which was costing him as much as $60,000 a week.
Who put this thing together? Me! That's who!
But maintaining his drug habit and hiding his financial crimes could have motivated him to violence, especially since he already admitted to a suicide for hire plot to funnel money to his surviving son. Finally, Alex has now confessed to several of the 99 indicted financial crimes. He's accused of stealing about $8.8 million, including embezzling about $3.7 million in 2019 alone. If he hadn't testified, all of his financial fraud, ripping off disabled clients, stealing money from a dead housekeeper's sons, wouldn't have been front and center in this case. After both sides rested, it was the jury's turn to deliberate. And to be fair, there were weaknesses on both sides. The prosecution didn't find the two murder weapons. They didn't have any direct witnesses to the murders, and they lacked forensic evidence that juries sometimes look for in this age of CSI, like a victim's blood on the defendant's clothes. Prosecutors guessed that the pair were killed at around 9 p.m., but they couldn't pinpoint a time of death with certainty. The alleged motive could also have struck some jurors as kind of weak. While murdering someone to cover up a lesser crime is not unheard of, killing your own wife and son over some financial crimes, it could be a bridge too far. And since the prosecution claimed that cousin Eddie left drugs for Alex near the kennels, the defense speculated that Eddie or Eddie's dealer friends may have been the real culprits. But these gaps in the prosecution's case are to be expected. Slam dunk prosecution cases often don't go to trial. And whatever weaknesses the prosecution may have had, the defense had vastly more. Alex said all of his bad deeds were caused by his drug habit. But maintaining his drug habit and hiding his financial crimes could have motivated him to violence, especially since he already admitted to a suicide for hire plot to funnel money to a surviving son. The Beach family's lawyer, Chris Tinsley, testified at trial that he intended to sue Maggie and Alex personally, which could have resulted in a huge verdict that would have destroyed their wealth.
He gets up close in my face and says, "Hey, Bo, what's this I'm hearing about what you're saying?" If you don't think I can burn your house down and I'm not going to do everything you're wrong, you need to settle this case. So I took it as he tried to intimidate me. He didn't intimidate me and sort of bully me into backing off.
As for the weapons, prosecutors said casings for bullets from a .300 Blackout rifle were found near Maggie's body. And the Murdaughs owned a rifle chambered in .300 Blackout, and the weapon is now missing. Alex also couldn't account for the clothing he was wearing on the day of the murders. His clothes have never been found. His mother's caregiver testified that after the murders, Alex tried to remind her about what he was wearing. He also tried to convince her that she misremembered the amount of time he spent with his mother that night.
He said, "You remember the shirt I was wearing, that Vinnie Vine shirt?" That's what he said to me. I don't remember that. I don't remember him wearing that shirt that day.
Alex said he was there for about 50 minutes. The caregiver told the police it was 10 to 20. All told, this is a case where Alex Murdaugh had to take the stand. Alex previously told police that he had not been to the kennels before the murders. The prosecution was able to prove through that Snapchat video that he almost certainly was. Under those circumstances, Alex had to explain the inconsistency himself. His defense attorney couldn't massage those facts or explain them away. Alex had to do what plenty of defendants have tried in the past. I lied about this, but I'm telling the truth about that. By itself, that's not impossible to do. The problem is it opened up everything else. All of Alex's financial crimes and the suicide for hire scheme, and his credibility was shot. His testimony ended up sounding like something else entirely. I lied about this, and I'm lying about that. The speed of the jury's verdict, just 3 hours of deliberation after a trial lasting a month and a half, speaks volumes. The day after the verdict was read, Alex Murdaugh was sentenced to 2 consecutive life sentences for murdering his wife and son. Rightfully so.
Yeah, credibility in front of a judge or jury is everything. Whether you're a lawyer or a defendant, your credibility is often all you have, and once you lose it, you never get it back. It's been fascinating to watch all the crazy twists and turns in the Murdaugh case, and one thing that has helped keep track of everything is today's sponsor, Morning Brew, because that's my favorite way to catch up with pop culture and the news. In fact, they've been covering the Murdaugh trial for weeks now. When I wake up, Morning Brew is the first thing that I read. I've actually been subscribed to Morning Brew for forever. It's one of my absolute favorite newsletters, and I'm thrilled to tell you why. Because Morning Brew, if you didn't already know, is a free daily newsletter delivered Monday through Sunday, and it gets you up to speed on business, finance, tech, and law in just 5 minutes. And it provides a fantastic quick summary of the most important issues while being witty, irreverent, and informative. And did I mention it's completely free? This week, I learned all about ChatGPT on college campuses, Amazon backing out of building HQ2 because, they're firing lots of people instead, and Chris Rock's new stand-up special. It's basically exactly the mix of news that I'm actually interested in and the stuff that I didn't even know I wanted to know about. And it's all written in a hilarious style. Morning Brew is one of the few emails that I actually open every single day. So Legal Eagles, this one is a complete no-brainer. Morning Brew is completely free and it takes less than 15 seconds to subscribe. Just click on the link that's on screen right now or in the description to get Morning Brew for free. And not only will you get a newsletter that you'll actually read, you'll actually help out this channel too. So click on the link below to get Morning Brew right away. And after that, click on this link over here for more Legal Eagle, or I'll see you in court. Why aren't states standing up to the president? Well, it might be because they are absolutely terrified of retribution. Take, for example, Maine. When the governor of Maine stood up to President Trump by having the temerity to suggest that Maine was going to follow the law, it did not go well. President Trump retaliated by cutting off funding for school lunches. But it might surprise you to learn that such tactics are legally dubious. Liz Dye has more because I just can't even.
Thanks, Devin. We often joke on this channel about Donald Trump being like a schoolyard bully who knocks down kids and steals their lunch money. But this time, it's actually true. President Trump is big mad at the state of Maine, and so he's grabbing the kids' lunch money, literally. The fisticuffs started on February 21 when the nation's governor showed up at the White House for an airing of grievances. It was a wide-ranging speech.
We just had the highest poll numbers I've ever had. It's just so terrible. I see pictures that you fortunately don't get to see. Even the Democrats are amazing people. FEMA was a disaster. FEMA wasn't there. We've done it the other way. And we're working with a very nice person. You fix it. You take care of it. I'd rather have you do it. You'll save a lot of money. You have a little bit of skin in the game, but energy caused our problem.
And all that was just in the first 15 minutes. 30 minutes later, he was still rolling, fantasizing about 2 transition people that were fighting in the women's boxing in the Olympics. That was apparently a reference to Algerian boxer Imani Khalif and Taiwanese boxer Yulin Ting, neither of whom is trans. Both these athletes were born and raised as girls. And the fact that there's been rampant speculation that they have some kind of hormonal or chromosomal advantage pretty substantially undercuts the claim that there are only two genders and everyone can tell the difference, which is something to keep in mind in about 15 minutes when we get to the part where the U.S. government doxes high school students it thinks are trans. Because these guys think everything is drag queen brunch, only not fun. Back at that lunch with the governors, lying about the boxers reminded Trump how much he hates trans kids getting to play pickleball and badminton, and so he decided to yell at the governor of Maine, Janet Mills.
Are you not going to comply with it?
I'm complying with state and federal laws.
We are the federal law. Well, you better do it. You better do it because you're not going to get any federal funding at all if you don't.
Did you catch that part where Trump promised to ensure that no federal money would go to Maine until the state started enforcing his executive orders barring trans kids from playing sports? Well, he meant it. But as it turns out, when he said, "We are the law," the president was confused, if you can even believe it. On his very first day in office, Trump signed an executive order defending women from gender ideology extremism and restoring biological truth to the federal government. Essentially, he declared that trans people don't exist and accused ideologues who deny the biological reality of sex of using legal and other socially coercive means to permit men to self-identify as women and gain access to intimate single-sex spaces and activities designed for women. He said that female means a person belonging at conception to the sex that produces the large reproductive cell, and male means a person belonging at conception to the sex that produces the small reproductive cell, which is wildly unscientific. For one thing, cisgender boys don't make any reproductive cells, big or small, until puberty. But Trump instructed his attorney general to treat these definitions as law for all government purposes, including enforcement of the 1964 Civil Rights Act. That's the landmark civil rights statute that bars discrimination on the basis of race, color, religion, national origin, and sex. The act protects Americans from discrimination in voting, housing, education, employment, and public commerce. And the Supreme Court ruled in a 2019 case called Bostock v. Clayton County that discriminating against gay and trans people at work counts as illegal discrimination on the basis of sex for the purposes of Title VII of the Civil Rights Act. That decision was actually authored by conservative Trump appointee Justice Neil Gorsuch and joined by Chief Justice John Roberts. Then in 2021, the Supreme Court declined to hear the appeal of a Fourth Circuit ruling that said forcing a trans boy to use the girls' bathroom was discrimination on the basis of sex under Title IX. In 2023, the Fourth Circuit struck down West Virginia's ban on trans kids playing sports and let a little girl named Becky run track with her schoolmates. So far, the Supreme Court has not granted cert on that appeal. But the court has been tepid on extending the on the basis of sex ban to the educational and health contexts. For instance, it allowed bans on gender-affirming care for trans kids to go into effect in Tennessee. That case has not yet been decided, but during oral argument, Chief Justice Roberts said the Constitution leaves the question of whether trans medical care is safe to the people's representatives rather than to 9 people, none of whom is a doctor. He meant the justices. It's safe to say that the law is kind of in flux right now on LGBTQ+ issues, and it's not at all clear whether the Supreme Court would uphold the right of trans kids to play sports. But that's not what President Trump is demanding. He's not saying that the state should have the right to ban trans athletes from competing on the team that corresponds to their gender identity. He's saying that Title IX requires states to ban trans athletes from playing. So on February 5th, he put out a second executive order, quote, keeping men out of women's sports, purporting to ban trans kids from playing sports as a matter of safety, fairness, dignity, and truth. And he instructed the Department of Education to yank all education funds from schools that just let the kids play. And he instructed the Attorney General to bring enforcement actions against states and institutions that refuse to comply. So when Governor Mills said, I'm complying with state and federal laws, and Trump got mad and said, we are the federal law, that's what he meant. He meant he'd signed an executive order that said letting trans kids play violates the 1964 Civil Rights Act, and he'd unilaterally declared that allowing trans kids to play sports discriminates against girls. But that did not make it law. The president doesn't make law. That's Congress's job, and he doesn't get to interpret the law. That's the responsibility of the courts, which was, of course, exactly where the dispute was headed. Trump's revenge tour started almost immediately. The very next day, the U.S. Department of Education's Office for Civil Rights announced that it was investigating Maine's Department of Education for violating the civil rights of female students. The letter said that allowing trans girls to play sports deprives girls and young women of equal athletic opportunities in violation of Title IX. Again, no court in the land has ever said that. And it pointed to Trump's executive order stating that it is the policy of the United States to rescind all funds from educational programs that deprive women and girls of fair athletic opportunities. Also that day, the Office of Civil Rights at the Department of Health and Human Services announced that it too was initiating a compliance review of the Maine Department of Education based on reports that the state was allowing transgender athletes to compete in women's sports in violation of President Trump's executive order. On February 25th, Attorney General Pam Bondi sent her own nastygram to Governor Mills saying, "Let me be clear, requiring girls to compete against boys in sports and athletic events violates Title IX of the Educational Amendments Act of 1972. This letter is weird. It's weird for the Attorney General to be sending out letters yelling at governors. It's weird that it just waves in the direction of the Constitution and Title IX without citing a single case or statute or federal regulation that supports the proposition that Title IX requires the exclusion of trans athletes, probably because there aren't any supporting statutes. And most of all, it's weird because it just says, now the law means the opposite of what it used to mean, so do what we tell you or else.
Respect my authority!
Investigations usually take months, but hey, wouldn't you know, the Department of Education and the Department of Health and Human Services were both able to conclude in less than 4 weeks that Maine was violating Title IX. But the first federal agency to hit Maine was the Social Security Administration, where Acting Administrator Leland Dudick cut off the ability of Mainers to report births and deaths at hospitals and funeral homes rather than going to a Social Security office. He was told that terminating the contract would result in improper payments and potential for identity theft, and he said it would be worth it because while our improper payments will go up and fraudsters may compromise identities, no money will go from the public trust to a petulant child, by which he meant Governor Mills. After major public pushback, Dudick reversed himself, telling the New York Times, "I was ticked at the governor of Maine for not being real cordial to the president. I'll admit I screwed up." But the first agency to really hit Maine was the Department of Agriculture, which administers school lunches.
Sorry to interrupt, but if you're going around stealing children's lunch money, you'll probably want a good lawyer. But if you want a great lawyer, let my law firm, the Eagle Team, help. If you've gotten in a car crash, suffered a data breach, especially if you've got a data breach letter saying your information might have been leaked, or are dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team.
On April 2nd, Secretary of Agriculture Brooke Rollins sent Governor Mills yet another nasty letter. She said, "You cannot openly violate federal law against discrimination in education and expect federal funding to continue unabated. Your defiance of federal law has cost your state, which is bound by Title IX in educational programming." Rollins is a lawyer with an admittedly impressive resume, but she clearly understands that this job requires her to say very silly things on camera.
What you have assembled in your vision is a turning point and an inflection point in American history. And so just being a part of that is the greatest honors.
Rollins said she was freezing federal funds for certain administrative and technological functions in schools. And she threatened to cut more if Maine refused to comply with Trump's executive order. She said, "This is only the beginning, that you are free to end it at any time by protecting women and girls." The letter also promised to review all of Maine's federal grant awards to root out funds that support a leftist socialist agenda, by which she meant feeding kids. Because although the letter promised that if a child was fed today, they will be fed tomorrow, the administrative and technological function she cut first was school lunch money. The very next day, the state was cut off from accessing funds for the Child Nutrition Program, CNP, which is administered by Maine's Department of Education. CNP administers the National School Lunch Program and the School Breakfast Program. It also feeds vulnerable adults in adult daycare programs. CNP could still access the funds for direct food purchases, but it couldn't get any of the money earmarked to pay the lunch ladies or for equipment or to administer the program or to support local farmers who work to supply Maine's children with healthy local food. Because the way to protect female athletes is to take away their lunch. The state of Maine filed suit a week later. Now, this lawsuit is not about Title IX, although it does point out that several federal courts have held that Title IX and the Equal Protection Clause require schools to permit transgender girls and women to play on girls' and women's sports teams. And it is not about the legality of the president stripping away unrelated federal money as a means of forcing states to do stuff, although the Supreme Court ruled in 2012 that the Obama administration could not withhold Medicaid funds as a means to force red states to expand Medicaid to ensure more poor people. It is about whether the president can arbitrarily withhold congressionally allocated funds without going through all the steps laid out in the statute. And the vehicle for that kind of a legal challenge is the Administrative Procedures Act. Under the APA, you can challenge something the government does if it's arbitrary and capricious. Here, Brooke Rollins just cut off the school lunch money from one day to the next. And as Maine points out in its lawsuit, there's a whole process to withdraw funds from federal grantees who don't comply with the terms of their grants. The secretary has to investigate and make findings and limit the cuts to specific programs that are not in compliance. She can't just say, I'm going to keep cutting agriculture funds at random until you change your school athletic policy, like she did in that pissy letter. And under federal statute and regulations, she had to tell Congress in advance what she was doing and why, which is another step she just skipped. The state moved for a temporary restraining order, and they got it. Judge John Woodcock, a George W. Bush appointee, wrote a 70-page ruling laying out all the ways kids in Maine will go hungry if the Trump administration cuts off CNP money. He said, absent a TRO, the funds that pay for the 12 CNP employees who monitor the National School Lunch Program and School Breakfast Program and process the reimbursements to schools are inaccessible. Without these funds, there will be no CNP staff to collect, approve, and process claims for reimbursement for schools and other facilities providing meals to children and vulnerable adults. In other words, there will be no way to get funds from the USDA to the schools and other facilities, and children will not be fed. Judge Woodcock ordered the Department of Agriculture to give Maine its lunch money and stop cutting off funds without complying with legally required procedure. Judge Woodcock also did something sort of funny, which was to impose a bond. Basically, if you lose a civil case, the other guy can start collecting damages right away, even if you appeal. And that makes sense, right? Because otherwise, you, as the losing party, could just drag out appeals for years on end and then say at the end, oh, sorry, I spent all the money, nothing left for you. But if you're the one appealing, you can post a bond, which is basically handing the damages award over to the court to hold during the appeal. Trump himself had to pay enormous bonds in the defamation and civil fraud suits he lost when he was out of office. But that gave him a bright idea. What if courts forced people who sue the government to post a bond? Now, Rule 65C of the Federal Rules of Civil Procedure does say that a court should impose a bond on the party that gets an injunction to cover the cost to the other guy if the injunction is later deemed to have been wrongly issued. But the rule leaves the amount up to the judge, and most of the time the amount is zero. Because judges understand that if you require bond in every circumstance, it would make it effectively impossible for poor people to get injunctive relief, right? The county could say, we're going to bulldoze your house tomorrow to build the interstate. And unless you could post a bond to cover the cost of diverting the interstate to go around your house, you'd have no ability to stop it, which is more or less what Donald Trump wants to happen. So the president put out an executive order saying that the Department of Justice should demand that parties seeking injunctions against the federal government cover the costs and damages incurred if the government is ultimately found to have been wrongfully enjoined or restrained. So on top of all the other embarrassing arguments the Justice Department lawyers are having to make these days, they're also having to ask federal judges to impose bond in the 11D7 cases where the administration has had a restraining order slapped on it. So here, they had to ask Judge Woodcock to make Maine post bond to give up for the grievous harm inflicted on the federal government if it had to hand the state the roughly $3 million allocated by Congress to feed poor children. Judge Woodcock thought about that one, and he decided he would impose a bond of $1,000, or roughly 0.0003%. Now, in most of the cases where the Trump administration got hit with an injunction, the Justice Department appealed immediately. But that's not what happened here. Instead, the state attorney general and the Justice Department jointly agreed that they would ask Judge Woodcock to leave the TRO in place. And I think it's not hard to see why. Because in its lawsuit, Maine pointed to all the times the Trump administration threatened to pull federal funding from the state because it supposedly violated Title IX by letting trans kids do normal kid stuff. But the one thing the Justice Department didn't do was file a federal enforcement action to test that spiffy new interpretation of Title IX in court, which was kind of a glaring omission. Like, if you really thought the courts would say that Title IX requires states to discriminate against trans kids, you'd file a lawsuit instead of trying to wield federal tax dollars to bully states into doing what you want. And so, to fill this glaring hole, the Justice Department did file a lawsuit of sorts. On April 16th, the Trump administration sued the Maine Department of Education. The complaint says, by prioritizing gender identity over biological reality, Maine's policies deprive girl athletes of fair competition, deny them equal athletic opportunities, and expose them to heightened risk of physical injury and psychological harm. The government says it violates Title IX to let trans girls play sports because undeniable physiological differences between males and females provide boys with inherent advantages in strength, speed, and physicality that predetermine the outcome of athletic contests, which manages to be both biologically and statistically illiterate. I mean, by that logic, any boy could beat any girl at any sport, which is clearly not correct. I mean, Billie Jean King's famous tennis match against Bobby Rigg, the so-called Battle of the Sexes, was more than 50 years ago. King, who was a pioneer for women's equality in sports, cleaned Rigg's clock, and she's been a strong advocate for trans athletes since then. Yes, I do know that there are plenty of weekend warriors who really honestly believe that they could beat a WNBA player, but that's not actual legal evidence, and it's definitely wrong.
Griner and BG gets her second dunk of the season.
The lawsuit cites zero case law to back up the claim that allowing trans athletes to play counts as gender discrimination under Title IX, because, again, there isn't any. Instead, it points to the non-discrimination mandate in the statute and to Trump's executive orders and says, now this law means what we say it means, which would be true if this were a monarchy. But since America is a democracy, Congress passes laws and courts interpret them. And since we're talking about the structure of American government, if Congress doesn't pass a law, the states get to make their own. Like Maine, which passed a human rights law in 2021 that protects the right of trans kids to play sports. But that's not the only thing the DOJ is confused about in this complaint. See here where they say federal regulations require that if an educational program separates teams by sex, the teams that the program designates as female teams must be completely separated by sex? Let's check out 34 CFR section 10641B, shall we? The first part says a recipient of federal education dollars can sponsor co-ed sports teams. Okay, cool. And the second part says where the recipient of federal education funds operates a team for members of one sex, but operates no such team for members of the other sex, and athletic opportunities for members of that sex have previously been limited, members of the excluded sex must be allowed to try out for the team offered unless the sport involved is a contact sport. So if there's no girls' soccer team, you have to let girls try out for the boys' team. And if there's no boys' field hockey, you have to let boys try out for the girls' team, which kind of seems like it means the exact opposite of what the DOJ is suggesting. The complaint goes on to talk about 3 high school athletes whom the government identifies as trans. We're not going to show you that part of the complaint because it doxes children, and we're not assholes. Also, Donald Trump thinks every female athlete who doesn't look like a swimsuit model is trans, so big grain of salt there. Let's just say the government is big mad that some kid won a pole vault contest and another kid came in 3rd place in a skiing competition and a 3rd kid is playing basketball, and I don't know if she's a starter or if she plays left bench, but I hope she's living her best life and the adults around her behave better than this. Okay, just a few more words on this goofy lawsuit, which aims not only to make Maine be mean to trans kids, but seeks money damages for the supposed harm to the government from allowing some poor 8th grader to run track with her classmates. The Justice Department says that before Maine passed its human rights law, 56 trans athletes participated in sports in Maine between 2013 and 2021. It's not clear if that's 56 different kids or like a dozen kids over 7 years having to get a waiver signed every time they signed up for fall field hockey or spring lacrosse or whatever. The source material says that of those kids, there were only 4 trans girls. So obviously, this is not a big problem. Governor Mills says we're talking about a grand total of 2 kids for the entire state right now. And so, to prove that this is too a thing, the Justice Department says that approximately 2,374 Maine high schoolers, or approximately 4.5%, identified as something other than their sex, and cites this as proof that boy athletes must be competing against girls in sports designated for girls. I mean, if you really believed that statistic, you'd be advocating to exclude 1 out of every 20 kids from participating in sports, which would be truly vile and cruel. But since we're talking about people who want to take away kids' lunches, I guess that tracks.
Thanks, Liz. Now, if you live in Maine, you probably don't want the Trump administration to see your IP address. You actually might want to set it to a different state, which is good advice no matter what state you live in, which is where today's sponsor, NordVPN, comes in. Because you know that incognito mode isn't actually incognito, right? Well, with Nord's VPN no logs policy, your internet service provider doesn't get to snoop on what you're searching, and neither does NordVPN. I especially like to use Nord when I'm using unfamiliar networks like the free Wi-Fi at cafes and airports. And Nord is more than just a VPN. It comes with a whole suite of threat protection tools. For example, if you follow some of your favorite creators on social media, you might have heard the stories of a channel getting hacked, basically a creator losing access after a successful attack or leaked password. This happens way too often. And NordVPN's threat protection includes specific features to warn you about phishing links, as well as features like a blocker for malicious ads and dark web monitoring to alert you if your passwords have been leaked. And of course, NordVPN is a great VPN. With Nord, you can surf the web anonymously, and your location stays private. It allows me to set my location all over the world, which lets me access the different versions of my favorite websites. And when I'm out of the country and try to connect to my Gmail or a bunch of other things that I'm logged into, all of these accounts would usually freak out and tell me that I'm being hacked. So now I just reroute my connection to the United States and my Gmail and everything else is happy. And not only is Nord the fastest VPN on the planet, but you get 24/7 customer support to help you whenever you need it, and a 30-day money-back guarantee for all users. So if you'd like to give NordVPN a try, click on the link that's on screen now or down in the description. Every purchase of the 2-year plan will receive 4 bonus months on top, and is completely risk-free with Nord's 30-day money-back guarantee. So click on the link below to get 4 months free and a huge discount with NordVPN, and of course their risk-free 30-day money-back guarantee. And after that, click on this box over here for more Legal Eagle, or I'll see you in court.